be thinking I've been live over here on YouTube. I had to hit go live. Y'all work with me. Y'all know I'm still getting used to all of this. Yo, I thought I was live over here. Hello, everybody that's over here on YouTube. Make sure you're hitting the like button as you come in, guys. I just downloaded all of the docs that we're gonna need for this live. And so I'm getting those docs pulled up so that we're able to we gotta go over these docs, y'all. I just, for the life of me, can't believe Adrian Loves is playing like this. Hi, hey Day, hey Brianna, hey April, hey Janessa, hey Tanisha. Tanisha, Miss Love is insane. It's the only thing I can come up with, y'all. The only thing that I can say is Miss Love, something's wrong with this lady, y'all. Something wrong. And I knew it was coming though. Y'all, I knew it was coming. Wait a minute. If you've been on my, hold on, I want that back over here. Go back. If you follow me, y'all know that I said I did, and I'm not trying to be like, I said this gonna happen, but y'all, I felt it. Like I felt like I could tell in the way I said, she's gonna try to revoke his probation. I knew she was going to try to do it. I knew she was going to try to do it because Miss Love just can't help. And Fani, child, they can't help themselves. They can't help themselves. Like neither of them can help themselves. This Miss Abbasi, and we're gonna go over we're gonna go over the overt acts that memo that she put out today. She said it perfectly. They are supposed to be after justice and not a conviction. It's very much given you want a conviction. It's very much given you want a conviction. Can y'all tell me where the like said on YouTube, please? Can y'all tell me where the like said on YouTube? I just y'all know I love Mounk. Y'all know I love him. And if Melanie had the funds, baby, I'd give him the biggest, baddest fucking lawyer to sue Fulton County. Get it, man. They be paying him when they get through. Thank y'all. Can we get the likes up on YouTube? Thank you, everybody on YouTube. Everything he keeps doing is backfiring. What do you mean by that? Someone said everything he's doing is backfiring. All of this has to do, y'all, what time is it on? Y'all, I'm on Central Standard Time, y'all. Y'all know I'm in Memphis. You can go to my YouTube from my my TikTok profile. I hadn't even seen that interview, guys. Thank y'all. Y'all, okay, I'm on Central Standard Time, guys. Hey, Armenia, we're on YouTube. Come over to YouTube. I won't be on TikTok long. I try to do both, y'all, but honestly, it's hard for me to read both comment sections. So somebody is going to feel left out, and it's always going to be TikTok because I'm over here on YouTube. Now I can figure out how to keep my live going for you guys on TikTok, but y'all won't be able to see the documents. On that clip of her campaign, she ran for DA. She said 100 gang convictions. Hey, Aisha. Yo. I didn't know Miss Jefferson was going live, guys. I hadn't spoken to her today. I was actually going to call her before I went live. So listen, if y'all gonna go over there, baby, go holler at Miss Jefferson too. Cause y'all, I know both of us about to be in these lives cutting up today. Hey, Detroit. Y'all know both of us about to be in these lives cutting up. So I didn't know she was going live. I literally, y'all, I'm laying down because let's talk about how I'm in Memphis. And we're going to talk about how Memphis DoorDashers pissed me off. You know, you can get everywhere in Memphis in 15 minutes. I ordered Chick-fil-A 15 minutes from my mom's house. Why did my food take almost 40 minutes to get here? when I saw what time you picked it up. Then I got my food and I forgot to order fries. So I was sitting here a little pissed. I ain't gonna even lie to you. I was sitting here a little pissed, y'all. And then I just opened my I mean, no, I was posting about the Diddy, because y'all know they found all these devices of Diddy. And someone messaged me and said they're gonna make an example out of Mounk. I said they're gonna make an example out of Mounk. Hey Steph. I said, why would you say that? And I'm thinking they're just kind of talking about him on social media or something. She says, no, they're trying to revoke his probation. I said, I know you lying to me. I know you are lying to me. No, guys, and I apologize, y'all. I did not know because me and my girl would have coordinated. I did not know Miss Jefferson was going live. I'm telling y'all now how I even found out. Once I found out, y'all, I said, oh hell no, I got to go on live. And I said, let me make a YouTube because I really would like. I would like to record this. So when y'all see me today talking about when we read this motion, it's literally live because I haven't read it, y'all. I have not read it. I haven't read it, guys. So TikTok, I can leave y'all up. I can't. I don't want to leave it up. I be having to go back and forth, guys. I'm sorry. You can go to my TikTok profile. My YouTube is in there. I'm gonna let these likes on YouTube get to 300 because I see it's almost 400 people in here. Can we get my likes up to 300 on YouTube? And I'm gonna close TikTok out. I do like to go live here first to let people know that I'm live. And then once we get an audience over here, y'all, we just rock out. And it's no telling how long we're about to be live right now. It's no telling how long we're about to be live. I don't know how long we're going to be live, but me and my people over here on YouTube, we like to rock out. I know some of them probably happy because court was canceled. Hey, Nick. Can y'all keep me abreast on the likes? Once we get to 300 likes on YouTube, I'm going to shut down TikTok. Thank you, Brienne. Thanks for coming over. It's why they're trying to revoke Mounk's his probation. Lord. Y'all, I just can't believe it. My YouTube is in my bio, guys. It'll take you right on over to me. My YouTube is in my bio. Come on, get the likes. India, I missed you yesterday. We went live randomly, and India, I was telling them how, I knew you had to have 4,000 watch hours to get monetized on YouTube. I said, I know India thought I was crazy because I text you and said, yeah, I'm not monetized yet. I only have 10,000 watch hours. It's because India, in my mind, girl, I was thinking 40,000. I don't know why I was thinking 40,000 India. I said that girl may have got off that. We were on Instagram messaging. I said she probably got off there and said, this girl is slow. It's not that I'm slow, girl. I really was thinking 40,000 and not 4,000. Yes, it was too much. Y'all, we want 300 likes on TikTok. 300 likes. And once we get to 300, I'm going to shut TikTok down. Hey, Ashley. Mel, you from the D? I'm not. This is my daughter's sweatshirt. Probably got this from Shein or something. I'm from Memphis. Making Doug jealous with that fancy printer over there. Oh, yeah. It's my sisters. Okay, TikTok. I have to get off, guys. It's on my profile, guys. My YouTube is Millionaire Mel. And it's, if you go to my TikTok profile, just click on YouTube. It should take you right on over. But I know that's right, Ash. Big South Memphis. Yes, ma'am. But it should take you right on over. Miss Sheila, we're on YouTube. I'm glad you went over. Yes, I'm on YouTube, guys. And my likes is up over here on YouTube. I always tell them once we get to a certain number of people, certain number of likes, shut TikTok down, and I move over to TikTok. For people just joining, please follow me over there. We are going to be looking at Mounk. The state is trying to revoke his probation. And then we're also going to read Miss Abbasi's memo that she sent earlier today. And we're going to key and we're going to have a good time because that's what we do on the YouTube over here. So yes, YouTube is already open. It's already up, guys. And I know they about to tell me, Mel, hurry up and shut it down. So meet us over there, guys. My YouTube is in my bio. So hey T. So Ariel, I just saw you join. Meet us over on YouTube, guys. I'm a hang up off here. I love you guys. Thank you guys for joining the little time we were on TikTok. But meet me on YouTube. I'll see y'all later. Bye-bye. All right. I'm here, YouTube. I'm here, YouTube. I have no words. I have no words. Okay, YouTube, you have me. Hold on just a second, y'all. Excuse me, Margie. Sorry, y'all. I got a little hot in this sweatshirt. For those of you that are joining from TikTok, we are discussing, and please like the live as you're coming in. That helps me subscribe if you're not subscribed, but it helps me get into the algorithm. So I appreciate that. I'm gonna apologize now if I start ranting and raving on here because we knew this was going to happen. First topic up is Tounk's probation. They have submitted a motion to have it revoked. Put a 1 in the chat if you knew this was going to happen. Put a 1 in the chat if you knew this was going to happen. I felt, hey Mike, thanks for coming over. There we go. I see the ones. I see, okay. So we knew this might happen. We knew there was a possibility that this could happen. Do y'all remember Miss Love asking him, well, what didn't you understand? Having Tounk literally sit on the stand and go one by one of which pieces of that plea he did not understand. Do y'all remember when she did that? I knew when she was sitting there doing that, it was going to be a mess. I knew from that moment, I knew it was going to be a mess. Y'all, she sat there and set this man on that stand and said, okay, number one. And she was, y'all, I remember her attitude, y'all. She was like, wait, which part is it? Oh, is it the part where it says, which word don't you understand? Hold on, let's back up. Is it the whole thing or is it just this word? Well, what is it? Like she took her time as if it almost felt like, I felt like she was mocking him. I did. I always felt like she was mocking him. I felt like she was mocking him, y'all. I just felt like she was belittling him on that stand. Those are the vibes I got from it. Now, who said don't cry? I'm not finna cry, girl. My allergies acting up. I think it's Memphis air. This time, y'all, I'm not about to cry. But I just felt it. So let me get his petition pulled up, guys. It's going to look different. I opened it with Google Docs, so hold on just a second. All right, so I'm opening with Google Docs, y'all. I felt like she was too. That's why he would get back with her. Yep. She does that to everyone she examines except Sprinkle. Y'all, we're going to pull it up. They told me what day it was. Okay, let's look at his petition, guys. Let's share the screen. Y'all, this is just annoying. All right, so hopefully I don't change anything. The state of Georgia, by and through Fani T. Willis, District Attorney for the Atlanta Judicial Circuit of Georgia, and the undersigned Chief Deputy District Attorney, Adam Abbasi, hereby moves this honorable court to revoke the defendant's. Hold on, guys. I want to see who's the judge they're talking to. They're talking to Paige. Revoke the defendant's probation in the above style matter in accordance with gives the law and other authority. In support of this motion, the state presents the following to the court. So if I don't read the case law, guys, don't be mad at me. You can go to Thugger Daily. You can get this same document. He also has a link to his Google Drive. So if you guys want to look at it in more detail, you can. That's what I do, y'all. When something comes out, I pull up his Google Drive. Says the plea of guilty by the defendant on December 28th, 2022. On December 28th, 2022, the defendant pled guilty to conspiracy to violate the RICO Act and possession of a firearm by a convicted felon. Chief Judge Earl Glanville subsequently sentenced him to 30 years of probation. The general and special conditions of probation were detailed in the final disposition sentencing sheet filed on that date. It's attached. Give me just a moment. The Alfred plea, guys, was the initial plea that they were talking about, I think from like 2015. This is the plea he took for this case, guys. So, Chief Judge Glanville, y'all know we got to call him Lawyer Glanville, imposed several special conditions to the defendant's probation, including a requirement that he fully adhere to all terms of the negotiated agreement. Damn, man. It says recorded citations will include matters taken from this final disposition sheet from December 28th, 2022. This is a footnote. The guilty plea hearing, and it's attached as an exhibit. To comply with these terms will be considered a violation of the agreement. Of pertinence to this motion are the following special conditions. So do you guys, are we all following what they're saying? She's saying because he got on that stand, he did not agree to everything in this document. He knew going in failure to do that would revoke his probation. Okay, we're all on the same page. All right. Defendant shall abide in full by each and all of the terms of his negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully. Now, where my people out that pick out a word, because truthfully stands out to me. Hey, Isis, truthfully stands out to me. But keep in mind, guys, from Lawyer Love's standpoint, he was being truthful when he signed it. So this is kind of becoming subjective, right? Instead of it being the truth being an objective thing, it's becoming subjective. And she's basing the fact that he got on the stand and told his truth. She said that's not what you were supposed to do. So, oh, sorry, y'all. Hold on, y'all. I got to tell my auntie I'm on live. Auntie, I'm on live. I'm going to call you back, okay? Okay. Y'all, my auntie is on her walk. Thought we were about to get it in and talk while she was on that walk. Okay. Let me actually turn my ringer off. Sorry about that, guys. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceedings stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each, Bart, you get down. You can't sit there. That each and all of the statements contained within the defendant's factual acknowledgments, section of this agreement are true. Do y'all hear that? I'm going to read that one more time. It says, in accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgement section of this agreement are true. So I take back what I said. The truth for him and Miss Love was definitely subjective. They were together. It wasn't supposed to be objective. Sorry, guys. I didn't know that was in there. This is my first time reading this too. This my first time. Y'all getting this is my first time reading this. That's why I got online. I got on YouTube. It wasn't an objective thing, baby. She said when you get on that stand, you better testify, because when you sign this paper, you're saying that this is true. So when it's time for you to get on the stand, you need to also testify as this stuff is written. And we know he didn't do that. We know he didn't do that, right? Okay. It says, defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case, when asked to do so in any proceeding relating to the facts alleged in this indictment. Child. Number 3, defendant violated special conditions of his probation. The defendant has violated all, goddamn, y'all. Not one. She said he violated all of the special conditions. She said all of the special conditions of his sentence outlined above. On September 4th, I'm glad she gave me the dates, 2024, he was called to testify in the trial of this case, with his testimony continuing through September 6th, during which he underwent both direct and cross-examination. During his testimony, the defendant directly contradicted the special conditions of his plea agreement by disavowing. My girl pulling words out of ass, okay? Not her ass, because disavowing is a good word. It makes it serious. You know, it's just like a marriage. She said we were locked in, and he got on that stand and disavowed everything that we were supposed to be doing. Child, Miss Love pulling out some words for this one. The factual acknowledgments he had sworn were accurate and true during his plea. His plea hearing on December 28, 2022. At that time, he had the opportunity to correct or clarify any statement in the factual acknowledgement before affirming their truth under oath. Y'all remember her asking him this when he was on the stand? Y'all remember on the stand, she was like, why didn't you say something at the hearing? Why didn't you do this? Did you have an opportunity to talk to your lawyer? Was your lawyer sitting beside you? This is why she was asking those questions. We all knew what she was doing. We all knew she was doing this, right? She kept saying, is that your lawyer sitting beside you? Is that you raising your hand? Which Mounk told us he raised his left hand, not his right hand. Okay. So she kept doing that. So it says, y'all, now she put the lawyer on, she threw the lawyer under the bus too. Y'all, Lawyer Love said at that time, he didn't do anything. He also confirmed, stop Archie, also confirmed that he fully understood the agreement and had discussed it in detail with his chosen attorney, Derek T. Wright. If I was Mr. Right, I would never speak to Adrian Love again. Stop, Barchi. Yo! She said, most importantly, the defendant acknowledged that he understood that any violation of the special conditions of this plea agreement could lead to the revocation of his probation, with the district attorney recommending the maximum sentence allowed by law in the Georgia Department of Corrections. So, and for people that's new here, y'all, we read and stop. We talk and stop. So I told y'all where to go. If you want to get it, you can go there, because we have some combo over here. But did y'all catch the last sentence? Most importantly, the defendant acknowledged that he understood that any violation would result in the special conditions could lead. Well, it does say could, guys. That's good. It doesn't say would. It says could lead to the revocation of his probation, with a DA recommending the maximum sentence allowed. Oh, God. Now, I'm going to say this, guys. It does say could. It doesn't say would. And you learn when you're looking at any type of contracts, when you're looking at laws, you want to pay attention to words like that. So could, yes, Ariel, that's another good point. Could, right? The word could is very is important here. So when we scroll down, they say Antonio Sledge, aka Mounk, and he said he verbally entered into a plea agreement freely, knowingly, and voluntarily without any force, threat, or coercion. I think that's a lie. It is evident that the defendant knowingly and willfully violated the special conditions of his negotiated plea agreement with the intent to disrupt the trial of this case. Therefore, the state of Georgia requests that this petition to revoke probation be scheduled for an evidentiary hearing, and the defendant be ordered to appear before this court to explain why his probated sentence should not be revoked in its entirety. Says, respectfully, Adam Abbasi. Mounk better take that money he making and get the best lawyer in Georgia, because he has to come up to the evidentiary hearing. I'm not a lawyer, but I'm sorry. I will put his intellect. I'm sorry. I wouldn't hire the lawyer that he currently has, baby. I would throw that lawyer under every bus I could find. Adam Abbasi, he is let me give you his title. He's the Chief Deputy District Attorney of Fulton County. Baby, I would not hire that lawyer. I would, baby, he's older. He doesn't look like he's old, but he's older. He can do with a suspension or not practicing for a year or something. I'm sorry. If I were a lawyer and I was trying to be strategic, I would put it on that attorney. I'm sorry, guys. I liked Mr. Right. And I'm not saying it's going to go to that, but if I had to go up there, I would put Moontoon's intellect on trial. The fact that he only has that 9th grade education, I would put that he doesn't, because I'm sorry, I could see he didn't really understand what he was reading when he was on the stand. Like, I think he just needs to get a new attorney. We'll look him up. He needs a new attorney. Mr. Wright can't be his attorney unless Mr. Wright gets in there and kind of puts it on him, because Mr. Wright was kind of saying it seemed like what he thought they negotiated, it doesn't sound like he checked it. Sound like he took their word. Right? Remember, it seems like he took their word and he went ahead and just had Moontoon sign it. But he did sit there when they read him out. He didn't object either. We don't know what Mounk was telling him when it was time to take the pleas. We just don't know. We do not know, guys. But I would that would be my plan. My plan would be getting another lawyer. Sorry, Mr. Wright, I love you. I know we family, but I think Mr. Wright, as an attorney, I think he feels bad for that plea deal because he knows he messed up. So I don't think he's going to feel away for Mounk getting another attorney. He might need Ashley, y'all. But Ashley already got Duke. I don't know if she can. There may be a conflict of interest there. She already has Duke. Because remember, when Brian Steele had the contempt hearing, remember Gunner's attorney was one of the attorneys that was representing Brian or Kayla. Can't remember. It was one of them. And Judge Glanville tried to say, well, weren't you already representing someone, her firm or something? He tried to point that out. So it may be a conflict. I don't know. But we're going to see. We are going to see we're going to see, guys. This is going to be interesting. Let's see what else is in here, because it is 50 something pages. Oh, this is so the rest of the pages, guys, are just the exhibits, which kind of show the special conditions stuff we've seen. The transcript, they put his transcript in here, which Miss Love was reading from. Let's see who Mr. Abbasi is, guys. What was his name? Adam. I mean, Abbasi. It's Abbasi. His last name was Abbasi. Hold on, because I know someone said they wanted to see what he looks like. Abbate. Oh, child. He is over the Major Crimes Division of Fulton County. Here's an image of him. Okay, here's an image of him, guys. Hold on, let me stop sharing my screen. And let's share the new screen. But yes, he is. Yeah, here he is. Here he is, guys. So this is Adam Abbasi, the guy that's at the top. And he's over the Major Crimes Division in Fulton County. So, yeah. He was also in Fani's case. I didn't see him, guys. I'm gonna have to go back and do some research on Adam Abbasi. This is my first time seeing him. But y'all, I just can't believe this. I wish I could sit here. I'm not surprised. I can say that. Let's see. Listen. He gonna have to do some key. Area Page is the big dog right now. Adams can't do nothing but recommend. Paige is the big dog, but what is Paige going to do? What is Paige going to do is the question, guys. Is Paige going to agree? Is she going to agree with the state? Does she understand what was going on with Mounk? What is Paige going to do is the question that I think we're going to see. Now they're going to set a hearing for this. And 9 times out of 10, it's going to be live. 9 times out of 10, the law is the law, India, but can you defend him within the bounds of the law? Can you offend him within the bounds of the law? You remember how Paige felt about her putting the attorney? Oh, yeah. She sure did, Key. She sure did, Key. Paige did take her up for him saying he already said he can't read. She did, Jade. EBS said, I know Paige said she hated here on the state about that lawyer being on the stand. She did, Miss Sheila. Key was just talking about that. Oh my, okay, yeah. I'm gonna open up the chat, guys, because I know y'all got things to say. Let's please keep it to 2 minutes and rotate. It's a couple of more of us in here that's normally in here today. So I'm gonna put up the chat. Please just respect the channel. Please don't curse. even if we have strong feelings about Miss Love, I will block you. Don't come on here. Don't call her out of her name. Let's just try to still be respectful. We could call a lawyer Love. That's disrespect enough. But guys, let's just try to still be respectful and not do too much cursing or anything on here. But no, it doesn't void this. It's not, it won't void it. It says she's sending messages to the upcoming witness. Ashley, I think that is correct. Yeah, so here's my thing. You better come to court prepared tomorrow. If y'all office got time to do all of this, child, you need to come to court prepared. Like, I'm gonna need you to come to court prepared because your priorities are out of order. It is intimidation. Sandra. Oh, okay. Hey, Sandra. I thought so. Hey, Sandra. It's y'all. They said she won't come prepared. You know, how do you think Paige feels, guys? How do you think Paige feels yesterday? She told them, get it together. You've got to streamline this case. It's unorganized. And then y'all got the time to come and try to revoke his probation. Ariel, I don't know how many more are on probation because remember, Woody didn't. Quindarius Zachary, he is on probation. He's on probation, but he doesn't have a plea deal. Woody didn't have a plea. Mounk is on probation and had a plea deal. Now, Duke, I think, may be on probation, and he has a plea. Duke has a plea. I bet she won't play with Ashley Merchant like that. She won't play with Ashley Merchant like that. Okay, I'm adding people to the stage. Hey, T. I can't hear you. How you doing?
I'm good. I'm good. I was in a good mood today. Now I'm stressed out. But let me tell you, Paige not gonna do that. But I'm gonna tell you why. Because when Woody got up there and said, I told him I was lying, she was like, well, that's their problem. And the way she got Woody a lawyer, I got faith. She gonna do the right thing. Love already wrecking her nerves. This is just something Love is doing. You say we couldn't call no names, but that's a dirty somebody.
Hold on. Because now chat, help me out. I thought I thought you started the conversation saying she ain't gonna do nothing, and here's why.
No, I don't think she's going to disagree. Right. She's not going to do anything to move to. That's what I'm hoping and praying.
Okay, I got you.
Yeah, because I'm just going by the way she's been handling it so far. I hate Melnick's still on suspension because that's who he need. But we need to call Kayla, somebody. But really and truly, Mr. Wright told the truth. He told the truth.
My girl Kayla needs to stay far away from this case. Let Kayla keep on working with her clients, okay? We don't want Kayla anywhere near the case. I'm a text her and say, Kayla, stay away.
But Kayla's
gonna stay away.
But thing is, she threw Kayla under the bus for Woody. So
which one?
Paige.
Paige was really rude to her.
Yeah. So I think if not that, I think Brian may find a loophole. Cause I
think we want Brian to do too much. Brian tired.
No, Brian to do it. He paid to do it. I ain't never ever in my life heard an attorney say, "Put me in the cell with my client." He built for this. He is. I'm trying to work on my job and this computer getting on my nerves. I was like, oh my God. And I was in such a good mood today. But it's all good. I do have a question. Can we buy his merch on TikTok? They stressing they fake auntie out over here, baby. I'm
gonna message him when we get off. I'm gonna message him because I do want to check on him, but I'm also gonna ask him. He said a website will be up, but he knows we're trying to buy some merch, so I'll see if how long it's gonna be, and I'll put it on my TikTok story or something for you.
Yeah, he got me up here like the old people with Obama. I'm gonna send him $5, $10. Look, it's crazy. First Quay acting a fool, but I see it's so much more to this story. And if I followed Miss Jefferson first, her and Megan, and I had been saying, y'all, we missing something. So then I said, okay, well, it could be political, and then I left it at that. But it's past that now.
It's too much.
I think love, like, if I go down, all y'all going. She doing her Nino Brown.
It's
But
too
I'm gonna say
much.
one more thing, and then I'm gonna
Yes,
let somebody
ma'am.
else. But I don't know if y'all watched Power Tommy's version, Force. Love Egg, just like Stacy.
Oh, I hadn't seen. Oh, is that that's the same lady from Chicago? From the shot.
The
Okay.
DA in Chicago. That's who she act like in real life. So y'all, we just gonna stay prayed up for our little nephews, cause baby, it's a lot. But they need to take words from Memphis. Paige need to look at Memphis, cause
Yeah,
baby, they did their
Memphis.
thing.
Memphis did their thing.
That
Memphis and
long
Edwards.
lived dog, but they did their thing. All
Memphis,
right,
they did.
and then
Thank
they got going
you.
about McQuan. I just can't take no more. All right, bye,
See
y'all.
you later. Thank you.
Ciao. Can you
Oh,
hear me
friend.
now?
I can. How are you today?
Ciao. Confused, annoyed as
Come
everybody
on,
else.
run them off. The emotions are
Right.
just, it's
Confused,
too much.
annoyed, pissed, just disappointed in just black people.
Oh,
That's really like, dang, man. You really want to try to send you setting us back.
it's
You
a lot. I think I've said this many times that there are so many things going on in this trial. It's not just about those six boys on trial. Like, it's bigger than them. Like, when you
it
start
is.
looking into it, it's so many different things that you can you could probably pick out a theme. And I mean, you can think about poverty in response to education, because almost all of the defendants have ninth grade or lower education. Like, how does that work? Like, there's so many things. You are
So
so
this is such a it's so anti what the purpose
right.
of our the system is supposed to provide. Like
Mhm,
when I was in law school, we took criminal law, they told us there are four purposes of criminal law. I
mhm,
can't recall all of them right now, but I do know that one of the purposes of it was um rehabilitation. I know retribution was one of them, but it's like you're not just throwing people in a cage for the rest of their life. What service is that doing to society? Like, what is that? What purpose is that serving? You like, I like Miss Love, and I know you said no disrespect to her, so I'm gonna try to keep it
just
respectful.
no bad words. Say it
No,
in a cute way. Say it in a
okay,
cute
but
way.
I just feel like her ego is on like it's about her ego, and a lot of prosecutors and a lot of people in political and government offices, they lead with their egos
Mhm.
because they're worried about their percentage of winning, and it's such a trial like of this magnitude. It is in It's important for her to pull out all of the whatever tricks out her hat or bag to try to get a win. So she's gonna do everything possible just to get a win, not to actually like present a legitimate case. We can
Mhm.
all see that this case is illegitimate. Like, it is really like a bunch of group of guys from the neighborhoods and things that we grew up around seeing, and even sometimes maybe have been involved in. This is not a RICO trial. This
It's
is
definitely not Rico. Oh, it's not Rico.
it's desperation. That's what this trial should be called, a desperation trial.
Every time someone says the word desperate, I think of Woody when he said Miss Love may as well been on her knees begging him. She was so desperate. Every time I hear the word desperate, that's exactly what I think about.
Right. He definitely did say that. But you know what? Like, what so with this recent motion that they filed to try to revoke Moontung's probation, it was really disheartening because
Mm,
I thought about it while he was testifying and during her direct of him and her redirect of him. I saw what she was trying to do. Um for the record,
yep.
so that she could then now have something to try to revoke his probation. The thing is, I personally don't think that the judge is going to sign off on this.
I hope not. I hope you're right.
Because are if you have any modicum of like humanity and empathy within you, which I do think Miss the judge does, I felt like she took a liking to Mounk as we all did, right? And so like, he didn't do anything wrong. He's just saying, I got this agreement 24 hours before, the night before it was signed. I didn't understand everything in it, but I was in a desperate situation where I just wanted to sign it so I can get out of jail. He didn't even, and then he admitted on a stand that he didn't understand some of the words that was included, and then Miss Love, she added extra information in there and then the lawyer didn't do his due diligence.
It's back to that lawyer, right? It's back to that lawyer for me. It's back to like,
yeah, I mean,
how are your negotiation skills? What I think
right.
He's got to take some of this blame,
No, for sure. And I think that he feels bad about it. I definitely know he probably feels bad about it. But him and Mounk were both in desperate situations because they both wanted to get out of the situation. Like, he wanted to get back to make it to his practice, and Mounk wanted to get out of jail. So they were both desperate.
It was. So, I agree.
So it was just out of desperation. And so just for her to utilize his testimony on the stand when he was under the impression that he would have the opportunity to explain himself despite agreeing to the terms that he didn't understand, I don't think this is gonna go through. So I mean, although I'm definitely like, praying for the best outcome, but I truly believe that in my personal and legal opinion, I don't think that this is gonna hold up.
Well, thank you, Bina. We gonna see. But thank you, girl. I'm gonna bring India up. Thank you so much.
You're welcome.
All right. Talk to you later. All right. Hey, India.
Hey, girl.
What's up, girl?
Nothing, but y'all gotta stop. There's a very high probability that he's definitely going back to jail.
Oh, wait, India. Wait a minute, you talking about the chat? I think he might go to jail.
I think he Paige is going to feel bad.
Wait, but listen though. I want to ask you something then, since you said that. We know that this is up to her. This is up to her. Do you think she's going to look at everything just like everyone else is? And say,
sorry.
You don't think so? You think it's over?
I think if he doesn't get sent back to jail, it's going to be on the grounds of his representation, that his representation wasn't adequate. He was misled. But all of that, his mom was sick. She felt bad. They were in a dire situation. Everybody in jail got a sob story. Like, please.
Now I got to pause you again, because although you don't agree with maybe their reasons, you do feel that there may be a reason, right?
Yeah, only the lawyer. That's it. That's the one reason.
But India, you sound like me. If I would get another lawyer, and I'm sorry, I know you got your loyalty to Mr. Right. Baby,
under the bus,
India. You hear me? Under one bus and another one behind, waiting to get on over them too.
Yeah,
he will be under because. He may not feel bad about Mounk doing that, because I think he gotta feel that some of this is his fault.
It don't matter how he feel. Mounk need to be smart enough to get him another advocate that's going to represent him well. And yes, that lawyer is going under the bus. The next one, and the next one, and the next one. Because at the end of the day, the thing about it is, a plea agreement is like a contract. You're agreeing to everything you checked off on. It's the same thing as when you sign up for, if you're doing services, if you sign up things that go with a job. Like, it's a contract, period. He basically breached his contract.
Like a marriage. What did Miss Love say? Disavowed.
Yes.
Yes,
So
and bad.
I mean, it is what it is. I mean, y'all could try to. Oh, she felt bad. I think she liked him. Paige ain't their friend.
Well,
Like y'all
I
gotta
think
cut
they're
that.
saying that. I think people are saying that in the sense that she could, in fact, humanize the situation
I
in
disagree.
accordance with the law. In accordance with the law, because I'm gonna say this about the jury too, and this is like scientifically proven how jurors do react to the way people look in court, the way prosecutors are, the way they handle themselves. You know, we were thinking about that in terms of, I mean, it's like basic psychology. You think you read people, the way they act. It can sway how you feel about the person. So we're not saying she gonna say, "Oh, I like him," and no, you're not gonna do it. But is it? What if it's like 99.9%?
I
That
don't.
could be
I
the
don't.
1%.
I don't see that happening. I don't see that happening. And like, I mean, let's be honest here. We're not talking about a first time offender who's never
Yep.
been in trouble before, who just
Mhm.
got caught up with the wrong friends. This is somebody who's been in the system. Like y'all, like I'm more so talking to the chat. Like, okay, these guys may not be the most articulate, not the most educated. These are guys that have been in the system all their lives. They
Mhm.
know more about the law than any law abiding citizen, unless they practice or they're just like abreast on the laws. They know more than we do.
Key said you gotta have a little bit of faith, India.
I'm a logical. I'm sorry, I'm logical, and all these emotions and all of that. We saw what Paige did with what's his name. Uh,
Quindarius Zachary.
yeah,
Oh.
she ain't stupid.
But let me tell you, I
She
think
was gonna
we
let
don't
him go.
know, but India, we don't know what Miss Love presented to Paige as if that man was running. We don't know, and we don't listen. After he got off the stand, he doesn't have the best credibility, so we don't know what was true in that situation. But it did feel like they were all basing their actions off of his father, who was not the defendant. Since
I
when
disagree.
did that happen?
I disagree.
Did you hear the call with his daddy?
I'm talking about before that when she was signing off on the material witness warrant and all of that stuff. Even after like they had spoke to the doctor and different things like that, like she wasn't buying it. Like she said it up on the bench a couple times. Like, I mean, well, we don't know if that's the reason why, if that's really what's going on.
Yeah.
Like
Yeah, Key right. Key said after we saw Quindarius Zachary, we got played. I'm sorry, Paige choosing to put him on the stand wasn't wrong. I agree with that wholeheartedly.
I don't feel like
I
people are
agree.
giving her. I don't think people are giving her enough credit. Like these, Paige ain't gullible. She see people like Woody, Mounk. She sees this stuff every day.
Mm-hmm.
Like it's not this salacious, like sensationalized thing as the YSL trial. This is stuff they see every day. It's not out of the ordinary. Well, this
Paige is
trial is,
wishy-washy.
but the people and things like that is not out of the ordinary. And like I said, this is not a first time offender who was just clueless, etc., etc. I think his only saving grace is that his lawyer didn't provide the advocacy that he should have,
Yeah,
because
I agree.
they read that thing. I mean, you can watch it. I mean, it was streamed live. You can watch it. They read that stuff out loud. He didn't catch
And
it.
he
His
didn't
lawyer
catch
didn't catch
it.
it. Nobody caught it.
Nobody caught it.
So, I mean, whose job is it? And I believe ultimately that falls on the attorney. That's what you paid them to do.
That's true. That's
So
true. Okay, India. So
that's his one and only saving grace. I don't think
India,
none of that.
you
He's a
know
nice
for
guy. There's a lot of nice guys in prison. Like
you gonna know for a fact after we figure out what happened. We coming back and we gonna see what was the, because it's gonna be streamed. We'll get to see why she makes the decision she makes. We'll see it live, y'all. Thank you, India.
oh, and one more thing, he better
Yes,
stay off them lives. He better watch what he be doing on them lives because he know they watching.
I told him that the other day he was on the live, but I think he does a great job of talking about everything but that trial. And but I'm gonna say this: he gonna have to, don't be driving on the phone, don't be around
Mhm.
anything. Like you've got to. I'm like you got to watch everything, everything.
All right, I'm gonna drop down.
Thank you, girl.
See ya.
All right, bye bye. Okay, I hope I say your name right. Is it Tyranny?
Yeah,
Hey,
Taranika, you
Tyrannika,
right.
how
Hey,
are
girl.
you?
Good.
I never get on or say anything, but
Welcome, friend. Welcome.
I be watching, girl. I be watching faithfully. But
Thank you.
I just wanted today. Just kind of, I don't know. They just rubbed me the wrong way when I seen that motion. I'm like, is she for real?
But
I
did you
get
not
it.
see the comments? Okay.
I get the situation and that he signed it and all the. I get all that, but I feel like she's just doing that because she's not getting her way.
I
And things
think
aren't
a
going
piece
her
of
way.
that is that. Yeah.
It's not about that he went against what he said. I just feel like it's not going her way, and so now she's just throwing a tantrum. Like that's what that feels like.
When we get through the panel, when the last person comes up, y'all, we've got to read Miss Abbasi's memo. She pretty much says, listen, they see this is not going their way, so we got to try something else.
Yes, and that's
she
what it feels like. And when it comes to Paige, I feel like she's gonna look at the whole overview of how this trial has been going and the things, underhanded things that they've done, and take that into consideration. So I'm kind of glad that the ball is in her court.
Okay.
And so just I'm praying for my boy. I hate to see him go back.
You gotta pray for him, and it's just sad because it really, when we talked to him the other day on live, he really is trying to change and try to figure some things out.
Yeah, I was on the live when he was on there with you and Miss Jefferson. So I don't know. I hope he do stay out of trouble, do the right thing, and things work out for him. But I just wanted to hop on and say that.
Thank you, Ternika.
All right, bye-bye.
All right, see you later. Hi, Toya.
Hey, friend. Hey, Mel.
Toya.
Girl, look, I was getting off from work and my little notification came on and I said, not Mel on TikTok. So I done put my earplug in my ear trying to get out the door. They trying to talk. I said, I got to go get on YouTube now. I am appalled. I am appalled.
Say it again. You're appalled.
I am appalled.
Oh.
But I think it's twofold. It's just things of questions that I have, right? One is I think the state is trying to set a precedent of we giving y'all these plea deals to get y'all out of jail. We're not going to keep tolerating y'all playing in our face. And so if they don't do anything about it, then anybody thereafter will continue to get up there and flip it. Right. And the way that it's making them look, I think they're trying to set an example. Two, I'm wondering, what the violation time is, because sometimes even if you get a typical violation without any new charges per se, it may be 6 months, it could be a year. So I wonder what the maximum probation revocation, because that's what it would be, is a revocation, what his maximum would be, since that's their offer, what the max would be if he had to do time.
Well, so I thought it was 30 years, but when he was on the stand, they was reading it out. I think the end number was 35 years.
But that's still not. See, a lot of times people, when they get in trouble, even though you got 15 years, but I'm on probation, I may still have to just do 6 months of a revocation, not my whole time sometimes. So I'm wondering, I guess we won't know.
I don't know. I didn't know that was possible.
Yeah, I mean, some people, if they don't catch another violent charge, maybe it's like a dirty urine, right? They'll get a probation revocation for a dirty urine, but they don't have to go do 5 years. They may have to just do 6 months for a violation. So I'm wondering what the statute is of the maximum, since they're asking for the maximum of his probation revocation. See, that's a difference.
Good. Now we need to find a probation officer to come, or you know what? We need to find a lawyer. I'll see if what Kayla's doing, or someone who's dealt with this before can explain it. One of my friends is a judge. I'm going to see if she has time and can explain it.
Because they revoke his probation doesn't mean he fits and go do 30 years. And I think that's what everybody's kind of like, oh my God, about. But a revocation could be 6 months. It could be a year. It could be, whatever the maximum in that state is for a revocation. So I think that's something that I, was wondering as well.
Okay.
And then too, with everybody saying about the compassion and so forth with Paige, right?
Mhm.
I do feel like at the same time, I feel like she's by the book, if you will,
Mhm.
not letting the defense or the prosecutors, do things that just absolutely don't make any sense. Because I do feel like, she knows it's a big case, her reputation's on the line. And so I don't think it's going to be a slap on the wrist for him if they do revoke it. I don't think she's going to give them what the state is recommending as far as a maximum. But I do feel like if he does get a revocation, it'll be the lightest of, just because she sees how the state is doing.
Yeah, I could agree with that. And India, we read his for the wise sale case specifically. We read his charges. He has two of the charges. I think it's count one, of course, the RICO charge, and then something else. But his charges in the wise sale case stem from that 2015, or I think it's 2015 thing he did with Quindary Zachary and the other little D. But we were reading. It's so crazy. We were reading the indictment yesterday
Right.
just to look at Mr. Huey's charges. So yeah.
And um, and I'm just talking from personal experience, right? Um, my brother, my son, has had to deal with the system.
Mhm.
And yes, we see that these boys didn't have the best environment, but we also see people that come from great environments, great loving
And
families,
still
and then
in
take
there.
the state. And then now, once you're roped in the system, it is hard for you to get that job, for people to allow you to move on because you moved on and they want you to live in your
They want you to
past,
stay there. Yep.
you know? And so I do feel like sometimes um some of these guys are getting eye openers, and then the form of social media for them to be what you want to call street guys, but are coming to social media. This is maybe a new way for them to make legit money, and
Yep.
to, what you want to say, humanize them versus it, because in black and white, it'll make you look a certain type of way,
That's true.
versus being able to see somebody's personality, to see how they engage, to see that, yes, if I know how to hustle, let me see if I can put my hustle into something positive, like the sweatshirts, or like Woody, he's going on some of these other platforms and doing videos and getting paid. And so hopefully, they'll come around and try to find another avenue
I hope
to
so.
make.
That's all I hope. I hope so.
Yeah, but that's it. I was taken
Thank
back when they
you.
said
I
that
told you I was bothered. I'm bothered too, so I get it.
yeah, and you see them trying to do good, and it's like the system just will not let you go be good. And I do feel like at the same time, if we're gonna hold him accountable for things that he's supposed to have said but didn't say, I think the attorneys as well, they have to
Well,
be held.
well, listen, Toya, we're gonna have to see. Hopefully his attorney's gonna come up. I mean, not his attorney. Hopefully he gets a new one. So y'all know we'll be watching and keeping track of it. But thank you so much.
Thank you, and I'm going to
Thank
the chat.
you.
Keep
All
going,
right,
sis.
see
All right.
you later. Bye-bye. Hey, Ariel.
Can you hear me?
Yes, girl.
Hey, girl.
Girl.
Listen, I got faith because, okay, you know how they have divorce court and it's
It's not
when
divorce
people
court. Come on, friend.
listen, listen, when they have divorce court and people have prenups, and then the woman will say, "But I didn't have enough time to sign it. Like I didn't have enough time to even do this. I didn't have enough time to do that." So sometimes the judge will end up saying, "Well, the time that can be a way to have the prenup thrown out because enough time wasn't had."
Mm-hmm.
So what I'm saying is, first of all, Muntu did not have a proffer, so he never sat down and negotiated anything. The next thing is he had 24 hours to go back and forth over
True.
5 different pleas.
True.
So that can play a part. I know people think it's the law, baby. It's loopholes in all laws. That's why people
Mm-hmm.
win lawsuits. That's why people get out of contracts. It's loopholes. And another thing is, on that stand, Miss Love did not deny one time that she changed those numbers.
She sure didn't.
She did not deny that. So that's on the record as well. She did not put on the record, you're lying. She did not deny it. So she knows she did it. So that's another thing. Like, if he's going to be reprimanded, she has to be reprimanded as well. And let's back it up. If he gets a great lawyer, that plea can be null and void because that wasn't the last plea that his lawyer got.
Yeah.
So it's, it's just so many things. I hate when people just think that the law is the law. Like, we're not lawyers. There's so many loopholes. As you can see, that's why there are appellate courts, because they find something that wasn't right in it. Brian has won over the 300
I
appeals.
think 300.
So think about that. So we can't just be so complex and just say, oh, it's the law, it's the law. No, that ain't how it is. And then even with this case, he doesn't have any violent counts in this case.
Yes, he does.
What does he have other than Rico? What does he have?
No, he has we looked at it yesterday. I just pulled it up on my phone. Mounk has the
Rico and the pew-pewing?
Yes.
Driving a car?
No, possession of a firearm by a felon. And then, that's in response to the drive-by that he did. That's in response to it.
But he was just in possession of a firearm, but he didn't pew nobody. Like,
of a felon. Well, here's the thing. Ain't nobody gonna tell us the whole truth. And especially after Quindary Zachary kind of saying what he said, you took as a 20, however old he was, you took boys to go light up someone's house.
Right.
You know what I'm saying? So I don't want to minimize what his charges were. That's not for me to do. But what I can do is say, hopefully he's grown from that and he's not doing it anymore.
No,
you get what I'm saying?
I'm not even talking about his actions. I'm just talking about what was in it. Like a pew
the
charges
is from there. Let me tell you, Ariel, because I think they pulled it up. Go ahead. I'm gonna look for it real quick, okay?
I was just wondering, did he actually pew somebody, or it's just a possession of it? Because you can have a possession is a possession. That's not a violent crime. A violent crime is you actually doing something with it. He just was in possession.
Remember, in his factual acknowledgments, it's that exactly is stemming from a violent crime. The like aggravated assault, I think, is what India is saying in here. From their house, the auntie was hit. He took them over there, like that whole thing. So that is violent.
Well, we're gonna see. We're
gonna see what happens. We're gonna see what happens. But like I always tell people, I'm not here trying to glorify what they did, but I do think people, if you're trying to change your life, change your life. But and he looks like now, I'm gonna talk about now, he looks like he's trying to change his life.
And people forget all the time, the law is the law. It doesn't matter if you did. I could go do something right now. If they cannot prove that I did it, the law is the law. And we forget that all the time. Look at Casey Anthony, the lady with the child. The law is the law. They couldn't prove it. We know she did it, but we couldn't prove they couldn't prove it. So that's what matters. And we have to understand that if we go on just our feelings, our judicial system is going to fail, because we don't even go by the law anymore. That's why laws are put in place to prove things. You have to prove it. It doesn't matter if someone done it or not. You have to prove that they did it.
We would need to, this would be probably a good question for Doug tonight on Taylor's Live, because I agree with you guys, but y'all have to remember, we read this, for those of you that are on here a lot, not double jeopardy. The Georgia RICO law is so broad. It is so broad. It's like a catch-all. Think about Thug. Like, Thug's 2 charges are count 1 and count 56, which damn near, they're not identical twins, but they could be twins. The RICO law, and then there's the gang law, where they still are saying he's the leader, the organizer. They're so similar. They can't be twins, but they could be sisters, right? So I do get what you guys are saying, that, hey, they've already been convicted of these crimes, which the factual acknowledgments, they went back to the 2017, put it in this agreement. So, we have to, it's like, if this is where we go back to, and y'all know I don't like to talk politics, but we go back to, this is where people, wherever you live at, it's important to look at the laws that are being passed in your state, because Georgia, it's too broad, y'all. I mean, I mean, when you look Georgia's RICO law, if you guys have read it, one person can be the enterprise. Thug could be the enterprise by himself based on Georgia's RICO law. It's really crazy. It's really crazy, y'all. And like India said, the threshold is very, very low. So I hope Ariel, I hope that I just hope I don't know. I hope within the law, Paige can find a way to tell this man, take your probation and sit yourself down.
Okay, I just want to ask you one thing and I'm gone. Do you think that, okay, they got all those pleas, supposed to got every plea from everybody that took a plea and all the emails back and forth
Oh yeah.
from Love has yet to provide all of that.
I kind of
So
feel this was the meeting. I think that's the meeting, Ariel.
if okay, they just sent this out for right, and that's what I feel too because they just sent this out for Mounk about a plea, and now maybe they took a day off. So what if it comes back that a lot of these pleas were changed before these guys signed them?
We're gonna see it. Paige said that it was so much information she couldn't digest it all in one sitting. So we're going to see. Doug Weinstein answered that question Sunday on Inside the Law, and he said that they should be reviewing them soon. So today, this big in chambers meeting, I personally felt like it could be either about that laptop, the stuff that was sealed, or it's going to be the emails. They're going to go through the emails finally. But
And
I guess we're going to see.
Clock this tea, and I promise I'm gone. You remember when Paige said, but that acknowledgement was never in any of them.
Oh, yeah. Yeah. Was that number 8? Was that number 8?
It may, I think, girl, I don't even know. I just remember
Okay.
her saying, but you can't say that because it was never in any of them. It was just in the final one. So she knows. People forget Paige is not just a judge. Paige was an appellate
attorney.
Yeah,
And she was over, yes.
So she knows a lot of things. We're just thinking regular civilians, regular lawyers. This lady was an appellate. She knows what can win in an appellate court. If that's a technicality, this was never on any of the original agreement. So how did they even have time to go over it? Then if that email was sent after court, that's a big problem.
That's what Key and people in the chat. It definitely was number 8. And she said Paige told Miss Love you snuck it in.
I'm gone, y'all. That's all I gotta say.
Thank you, Ariel. I'll talk to you later, girl. Hey, Miss Sheila.
Hi, how are y'all?
Miss Sheila, why they
don't get started
early in the day? They got it popping too early in the day.
Look, Miss Abbasi pissed her off. Let's just be honest. Miss Abbasi pissed Love off, y'all, with her motion when she told her you don't have a case. Yeah. So on that note, she came and said, well, I can show you. I think I got a case because I'm finna revoke his probation. No, Love, don't do that. You're just gonna make yourself look even like a more bigger fool than what you already look in court. Why would y'all even do this? This is crazy work.
I knew it was coming, though. I knew it was coming.
That's just like us saying, okay, Justin, instead of giving you life, we're gonna give you 10 years and let you out.
Yeah.
Do you not know how stupid and crazy that look? You on film and then
India said we know that Mr. Abbasi wrote it, India, but who you think gave the order? I think it was Funny. I think Funny and Miss Love, because baby, let me tell y'all something. Every time something like this happen, y'all know what I picture? Miss Love in her war paint, black shadow and a wing.
But did you not notice? They threw Funny name in them 2 motions like the judge was going to say, oh, well, Funny name in these motions, I'm going to agree to them. Just said no.
Look back. I think her name is always there. I got to look back because I feel like Funny's name is always there.
Baby, you can't get done off a name.
It's just too... It's too much, Miss.
That's just like them calling. As Gator said, that's just like them calling the little sick boy up there on the stand and expecting for him to act right. I couldn't believe as a detective you would call that man a sick boy, that little sick boy. Huh? That's what she said when she first got on the stand back in April. She called him the little sick boy.
She's always gonna be like that. She's
But
always gonna be like that.
tell Mounk to go ahead and put them shirts up so we can go ahead and raise some money so he can get him a good lawyer.
We're gonna have to.
We ain't got time.
I'm gonna tell him.
Yeah, because this some BS.
Sick D. That was his name, India. Sick D that's what his daddy said. They call him too.
Sick D.
Sick D. Yes,
She called that child Sick D. But I'm gonna go back to what you and Miss Jefferson said. None of them boys were really supposed to have made anything out of their lives. They supposed to have been running in and out of jail. And the state's so dumb, they playing phone calls that say, Jeffrey won't even give us no money, man, so we can go to war with these people.
Listen.
That really.
He said that, Miss Sheila.
And I'm like, is the state crazy?
Buy a shirt, Miss Olympia, so at least you'll get something out the deal. Just buy a shirt. Buy a shirt, Miss Olympia. That's what I would say. They said Moon.
I mean,
his bio has the link to his website. I would just say buy a shirt. That way you won't feel bad if he take that money and run off to Mexico. You won't feel bad about it. You got a product. Yep. You won't feel bad.
My phone breaking up so bad. I'm in South Memphis.
Don't do South Memphis like that, Miss Sheila.
Okay, I ain't gonna do y'all like that. But no, it might be the area I'm in for real though. But this is gonna be a whole lot of backlash like it was over Quindarius Zachary. It's gonna be a lot of backlash. We saw it coming. We had a feeling that it could come, but we didn't think that it would come this fast.
Yeah, I don't think we thought it'd be this fast.
And with them wanting to look at everybody, I think she was mad because the defense broke down Tounk's plea deal to him on national TV.
I mean, when they played it in court, we knew what she was setting him up for. Then to call his attorney, the questions she was asking him, we knew what she was working up to.
And then even she came back the next couple of days and was still asking Paige, well, can I get this in for what do they call it? Impeachment? Paige was like, no, I'm not allowing that in. I'm not allowing that in. I'm not allowing that in.
She wanted to.
Right.
And it was her attitude. And she was mad. Miss Sheila, I'm gonna have to pull it up because you remember one of the first things she asked him, he was like, no, she said no. She looked at him.
Yeah.
Did she say no? Like she almost broke her neck.
And then falling back in that chair. She gonna do a lot of falling back tomorrow. Because Miss Abbasi is gonna be there. And don't try to bring Hilton up to argue with Miss Abbasi because ain't neither one of y'all on Miss Abbasi level. And Miss Abbasi is a public defender. She is a public defender making y'all look bad.
Yes, they are ready. They said he testified. They have to get everything out before the election happens. People keep saying that, but we're going to see what happens, guys. We're going to see what happens. She sure did dance. We'll see Damon Ray and Miss J. I see you guys. I'm going to pull you up in just a second.
Yeah, they can go ahead, baby, because I'm finna go see my baby girl out here at Calvary, and then I'm going to head home. But
well, I hope you have
I'm going to drop you down.
Miss Sheila, I wish my mama was that close. She's in Coldwater. I haven't been since we put her there. Maybe while I'm here,
while you leave town. Yeah,
while I'm here, I'm gonna muster up the courage to go out there. She's in Coldwater, so
that ain't too far.
No, it's not far. It's not. But have a good visit, Miss Sheila.
Yes, ma'am, and y'all have a good one. I'ma stay prayed up that he ain't going back. If he go back, it'll probably be for 60 days. But if he go back, she probably gonna offer him another deal that's even worse than the deal she offered him because she really want him to testify.
She really does. She want him to throw them under the bus, and I think that was Tounk's problem. Once he probably got closer to, because initially, guys, they said he probably wouldn't be testifying. So at some point, I think around Woody's testimony, it changed. Like, oh no, we might have to call you. We might have to call you now. He was not supposed
because They asked Woody, "Do you love them guys?" Each one of them, Woody said, "Yeah." They asked Zachary that. Zach said, "I don't love nobody but myself." Okay, but Moon said he still loved those guys because those guys he was close to them because they were little boys when Moon was in his 30s. So they were like kids to him. They Moon step kids. But Miss Love is really acting like a 304.
Oh, well, thank you for
And for
saying.
those of y'all that don't,
Thank you for
and for
saying
those of y'all that don't know what a 304 is, put 304 in your phone and turn it upside down. That's what we used to do.
Bye, Miss Sheila. We're gonna
But
let you
y'all
go.
have a good day.
Have a
Bye.
good
Y'all
day.
have a good one.
Bye bye.
Bye.
Okay, y'all. We're gonna look at Miss after I got two more people up here, and after this, guys, we're gonna look at Miss Abbasi's her memo today. It was really good. Really it was definitely giving my type of timing. Hey Day, how you
Hey
doing?
family, I'm a little upset. I'm a little salty
Oh,
because I hear India's side, and I go like you said, the human side of it. Yes, I'm not saying these boys were saints. I'm
mm-hmm.
definitely not saying that. I'm not saying they walk no straight line. I'm not saying that they were these good, wholesome people, that did all these great things. But I just really feel like everything and most of her motives and her actions are personal. That's not
Oh yeah.
justice.
Yeah.
That's not justice to me. If I
I
was what
agree.
if I was Peanut's family, I would really feel so like are you serious? Like you just gonna try this and keep rubbing this in my face that you know who took my loved one, and you still decided to wait because you thought this was bigger?
And
Just
that's the
adding him to
problem,
that?
Day. That's the problem. Where are the victims in all of this? I think we've lost it.
And
India
that's what I'm
said Miss Love
saying.
is spiteful. Baby,
Yeah,
yes.
love is more than spiteful. And if you read in the Bible, you guys read the scripture where God tells us that he says, vengeance is mine, says the Lord. She
Mm-hmm.
is spiteful. And yes, I'm going to always go back to the godly way. Like she just said, we need to really do a corporate prayer for him. We need to really be on our stuff, because I really do think his saving grace was his improper representation. And I think
Listen.
that
I know y'all. I know my girl got y'all salty in the comments, but my friend India definitely said that's gonna be the saving grace, and I
it's going
agree.
to be his saving grace. Other than that, it's so true. And like
Yeah,
she said, a lot of people want to more so put the emotions in it. She's removing
can't do
emotions and
it.
she's saying reality.
That's
And
why
this is
she
the
not here
justice system. This is where we
though.
are. This is how it goes. Yes, and I agree with Ariel
Hold
too.
on, Keisha. Lakeisha said his lawyer did nothing wrong.
Huh?
Yeah, Keisha.
His lawyer didn't get a whole
Keisha.
number 8. He did a lot wrong.
Keisha. You pay those. Well, let me say this too. It don't sound like you really paid Mr. Wright any money.
Too much, yeah.
It
And
don't
like it
look
was more off the principle because
it may be
because of
off
who
of the
you are.
relationship, you know.
And his family.
But let me tell you this: I have friends that are attorneys, and most of you guys are aware. When I sued the IRS, I went with a friend, and well, a friend of a friend, and me and this girl became cool. I lost that case. There is something about when you use family, they have to be as well. This was a friend, and I think maybe we were too far removed for her to feel the way I felt about the case. And we didn't have the relationship that Tounk and Mr. Wright had, but I'm saying sometimes I think they get really lax in representing you because there isn't this, you didn't pay them $5,000-$10,000 to do it. So I do agree there.
Yeah, and I think it's like you said, when you get the mixing personal with business, it becomes a little issue. And
Yeah.
again, like I think for me, like I'm Team Woody all day. Like, don't come
Mhm.
around me talk about no Woody, because baby, that is my bruh. Bruh, listen, don't come up again. I'm not saying he was right. What I'm saying is
Yeah.
most people that is pointing the finger at these young men, he snitched, he this, he that. If you was on the other side of that table, you would have did the same thing. So before you pass judgment, put yourself in that seat. And I just really feel so bad for him. Like, it really made me, like, I was so in awe when Taylor went live and she was about to cry. Like, I was like, what? Because he was in her comments, and I really want you to, I mean, he was saying, like, I want you to talk to him. Like, he really got to be a little bit smarter and not let the emotions show, because his emotions will cause him so much more trouble in this situation right now. I want him to
Oh,
be.
y'all talking about y'all? This happened today.
Today, she was live right
Oh.
before you, because I swear, I still got my message sitting in your inbox, and I said, Lord, I'm being unindicted co-conspirator, because I was about to say, Mel, I gotta call you. What's your number? Because they don't put out a motion, but I was scared,
Girl.
so I didn't send it. So then I thought back, and then I see him in the comments, and he was saying, he wasn't saying bad things. He did say F her or whatever the case may be. But I say all that because I see his respect level for you, Miss Jefferson. Like you know what I'm saying?
Like I mess with him.
Remember, I just told you, like, that was so funny. Like, you can
You
laugh.
did.
He's so personable. Like, he remind me so much of my cousin. Like, he's just this big, gentle giant that's always on jokes. How he's a funny person. And again, like India said, I'm not removing that. I get it. I really do. But what I'm saying is, this will be different for me if she was turning over something that, because she maybe not have had evidence for one of the families, and now she found the evidence, or some DNA came up, and now you about to charge this young man. Because that's what I'm saying. But to smack these people in the face, and remember, we naming even more people that I never even knew more about. I just really feel like this is not justice. This is personal.
It's personal, and hopefully they we don't know. Y'all know we are,
because
we
remember,
to be here till March, but
I don't know.
God may have a trick up his sleeve, and I
really got to listen to you with your next part, because I keep hearing about this Abbasi or whoever this is and getting the bits and the pieces of it. I didn't know really much about her. I just think, to me, I'm just looking, even the unethicalness of love. Like, I've never in my life, I watch court. Listen, I have watched so many trials. I'm like Ms. Jefferson, I just love watching it. Current events has always been my thing. I like to watch. I like to tune in. Now, this one, really, I never expected to get this attached. Like I told y'all, you, Dummy, Smack, like y'all is with me. I'm like, dang, like I need to really tune in. But this right here, I can also say this. If this wasn't as talked about and as many people, are really paying attention and following, even I think the Black law student is doing an interview with someone else as well tonight. So if this wasn't as followed, could we imagine how much more would have been swept up under the rug?
And that, but see, it makes you question what's going on in courtrooms where the defendants don't have the money as those that are in the YSL trial, where there aren't cameras to pick up stuff. Yes. What's happening in those courtrooms? Like, I think so many of us, we hear about the justice system, but we are seeing it right, like in 4K. Every day.
It's like, even like you said, we're halfway through the day. I'm like, okay, because at first I'm 9 o'clock, I'm sharp, I'm at work, got my earphone in, sneaking, like, hold on, why the case? And I thought about it. Oh, it's no case today. And then, like you just said, who knows what this meeting was about? They're saying something in reference to this laptop. We don't know really what the meeting could have been about.
We don't know, and people keep trying to figure like we don't know. But I don't know. My money is on it's probably those emails. Like, what if Paige found something?
Is this the emails that Steele was mentioning?
Remember Keith Adams and Doug Weinstein, once they start going through Moontunk's lawyers' communications with Miss Love, and
they wanted everybody.
They're like, we want everybody emails. And Keith Adams said, not just emails, we want all communications. Text messages, whatever. And they're not gonna trust Miss Love. They're gonna reach out to those attorneys too. So they want everything. So,
because I do believe what the other lady said, she's definitely about a book. Now, as far as how is Paige going to proceed and move forward, because I think she would have to push it back over to his probation judge. That's who that's going to rely on. And again, we know that birds of a feather flock together. It's Team Blue. It may not be the PD Team Blue, but they Team Blue, and they going to stick together. I just really want him to really get him a lawyer. Get, like someone in the comments just said, that's what's going to matter the most.
Yeah.
He need to go ahead and get Miss Steele. See if she can give him a great deal. And we might be all right. But anybody else, Mr. Right ain't right.
Oh, yeah. So we're going to see. We're going to see. Thank you so much for coming up. Thank you.
You're welcome.
All right. No, Glanville took his plea, India. It was Judge Glanville. Jay, something's wrong with your device. It's not connecting. So while Jay is connecting, guys, let's go ahead and read Miss Abbasi's. She submitted something too. Overt acts. Now, this is the one I told y'all I really want to find the date. This argument was good, okay? What Miss Love was trying to argue is if they added overt acts that happened after me, because a lot of them got some charges while they were in custody. Miss Love was trying to add these overt acts to the trial and then say that if they're found guilty of those overt acts, and then the problem is some of the overt acts, guys, they are the statute of limitations has run out. So Ms. Love was trying to add new overt acts on, hoping that they're found guilty of those charges and then subsequently found guilty of count 1. Now, I don't know, India. I don't know if this is going to be argued tomorrow. So what Brian Steele was arguing is, if the jury found, I'm going to use who on trial, y'all? Let's use Shannon. If they found Shannon guilty for one of the overt acts and the statute of limitations has passed, he can't be found guilty for count 1. That was the argument. And so Miss Love was saying, no, that's not true. So Brian Steele was I don't want to sit here and lie to you guys. I want to say he was telling Miss Love that you can't do it. I don't know if the argument was finished, or are we waiting on the state? I don't know if we're waiting. Oh, they said day 114. Who in the chat is on it? I know it was at least within the last couple of weeks, because I was taking my niece to the hospital. I remember being in the car. Okay, y'all, we're gonna let it play, then we'll see. So she represents Lil Rod. This is a memorandum of law regarding overt act requirement. Comes now the defendant Rodalius Ryan Jr. in the above style matter, and submits to this court as requested the case law on the constitutional protection and substantial safeguards in place before the state strips a man of his liberty, that a defendant cannot be convicted solely on the basis of overt acts not included in the indictment. Ryan shows as follows. Count 1 of the indictment against Ryan alleges that he conspired to participate in a criminal enterprise known as Young Slime Life, YSL, which engaged in a pattern of racketeering activity outlined in 191 overt acts. God dang. The state claims that they need not prove any of these overt acts, and a conviction may rest solely upon an overt act not included in the indictment. So for those of y'all, are y'all following? She basically saying when the grand jury indicted these guys, never mind those charges. Even if they get found not guilty, let me add some more charges. Let me just add some more charges that the grand jury didn't even indict them on. That's what Ms. Love wants to do. Okay. It says that the state claims, we read that. The state urges this court to ignore not only the RICO statute itself, but also centuries of antecedent development of common law, going back to, I think this is Aziz of Clarendon in 1166. I'm going to have to look that up. I don't know what that is, guys. Russell versus United States, and it gives some case law. It explains the history and the purpose of a grand jury indictment. That is to provide a fair method for y'all, I don't know this damn word. I don't know this word. Hold on, y'all. Criminal proceedings. I'm gonna look that up as soon as I finish reading this. Against persons believed to have committed crimes. Instituting. God damn, how the hell I messed it up? I'm sorry, y'all. I saw something else. That's instituting. The Constitution itself, federal, state, jurisprudence, as well as the RICO statute, requires that the indictment contain the necessary elements, which include the overt acts which form the criminal conduct. The state must then provide evidence to prove that the acts which support the charge. What they're saying right there, they're saying is, she's basically saying that we have a grand jury for a reason. They convene, they indict people for a reason. What kind of country would we be for us to have a grand jury, they indict someone, and then they can come back, add something that what they weren't even indicted for, and be charged for it? What are we becoming? That's not how the law works. Those new charges need to be tried somewhere else. They need to be tried separately. Okay, hold on, y'all. It says that the Fifth Amendment The state may not rely on whatever conveniently arises to create an overt act, which could support a conviction. Doing so would violate due process. Like, that's you can't. How can you do that? How can you do that? You can't make up the law, guys. That this is what Miss Abbasi is saying. You don't get to just say, "Oh, this just happened. I'm gonna add it on to this case." That's not due process. And according to our Constitution, we have the right to a fair trial. We have the right to due process. Okay. All right, so the Fifth Amendment, she says the Fifth Amendment right to indictment by grand jury protects a defendant from conviction based on acts not contained in the indictment. Have y'all ever heard this before? I know a lot of us have watched a lot of Law and Order. I have never seen people be indicted. I mean, people be tried for things they weren't indicted for. Like, this is insane. The Fifth Amendment of the United States Constitution provides that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service of time, of war, or public danger. Talks about the United States Constitution, Amendments 1, 5, and the Georgia Constitution, Article 1, Section 1, Paragraph 5. An indictment, including this indictment, reflects what was presented to the grand jury. The grand jury may or may not have heard about the unspecified incidents that the state now wants to adopt as overt acts. Any conclusion, one way or the other, about what was presented would be a guess. To allow the prosecutor or the court to make a subsequent guess as to what was in the mind of the grand jury at the time they returned the indictment would deprive the defendants of a basic protection, which the guarantee of the intervention of the grand jury was designed to secure. So it's almost like, y'all know how we're going through this a lot with the state. Y'all hear how in this case we hear a lot of "I believe," "I think." Well, I think what he's saying in this call. How can you know what these people are saying? How can you know what these people are saying? It's like, how does the judge allow them to guess so much? Okay. Hold on, we're gonna go down to allow. We read that already, and then it gives some case law, guys. The language is clear and unambiguous. There is no alternative to reading which would permit the state to try and convict Ryan for conduct which was not presented to the grand jury. She talks about the Sixth Amendment. That one demands that the indictment inform a defendant of the acts which constitute the crime alleged. What is she saying? She's like, you got to tell me what I'm being charged with. And you got to tell him the nature of and the cause of the accusations. So she gives the United States and the Georgia Constitution for that. The state, she said the state would like to completely dispel this requirement and rely on conduct not included in the indictment. Baby, she talking bad to them. Miss Abbasi said, I know these lawyers and I know their game. They want to focus on everything but the law. Everything but the law. Everything but the law. So she gives all of her law that's going to back her up. I know that's right, India. You see that case law in there. The two requirements of an indictment are that they definitely inform the accused of the charges against him so that he may present his defense and avoid surprises at trial. What did they say? No trial by ambush. And that it protect the accused against another prosecution for the same offenses. That's that double jeopardy y'all were talking about. Ryan is unable to prepare for a defense, and that's interview witnesses, subpoena evidence, and file motions to unspecified acts. She said, how y'all gonna have me up here fighting for the man and y'all pulling stuff that we don't even know about? We don't even know that y'all want to pull this stuff up and charge him for it. So how can he properly prepare? That is in itself a trial by ambush. She says that by its own representations, the state is still trying to decide what evidence. Ooh, wait a minute, y'all. She said from 2 terabytes of evidence provided. So what she's saying right there, y'all got all this evidence, and 2 years later, y'all still trying to decide what you're going to use against him? That they will actually try to introduce to prove the 191 acts in the indictment. So not just him, y'all, everybody. The state's position would require the defendants to identify the evidence relevant to the acts, which the state may not have even thought of. Oh, God. Or which may not have even occurred yet. This would leave the prosecution free to roam at large, to shift its theory of criminality so as to take advantage of each passing vicissitude of the trial and appeal, a practice the Constitution prohibits. She basically said, did y'all, Miss Abbasi said that they gave 2 terabytes of information to them, right? And then they want the defense to go out and pick out the evidence. Let me make sure I'm reading that correctly. The state's position would require the defendants to identify the evidence relevant to the acts. Where they do that at, y'all? Where they do that at? This is why Paige goes through what she goes through with them. She asks them, what I want you to tell me the witnesses and what evidence you're going to be using. Paige is doing this on purpose because it must. Miss Abbasi said if we had to leave it up to the state would just give us all this evidence and we just figure it out once we know what they're going to use once they got into whatever questioning they have. Child, okay. Let's see what else. To prove RICO, the state must prove at least 2 of the predicate offenses in the indictment, and she gives the law for that. Where here, the defendants are charged with conspiracy to commit RICO, a person may be found guilty of a RICO conspiracy if they knowingly and willingly join a conspiracy which itself contains a common plan or purpose to commit 2 or more predicate acts. We looked at the predicate acts. That could be, the predicate acts could be anything. But what she's saying here, I'm gonna go back to this, y'all. Do y'all hear the key word plan? They have to have a plan and a common purpose and goal. She says the inclusion of improperly charged predicate acts, the equivalent here, overt acts not charged at all. Miss Abbasi is my type of girl. Will not void a conviction if 2 remaining predicate offenses support the conviction. And she gives the case law for that too. It says upholding a conviction where the evidence in this case supports the jury determination beyond a reasonable doubt that, this is about the case law, Mosley committed at least 2 predicate offenses as charged. The inclusion of an additional act does not satisfy the requirement the state proved that an act charge. The state cites to Georgia. She gives the case law there. The state need not prove that the defendant himself committed the overt act in the indictment, just that at least 1 member of the conspiracy did so. This is accurate and not the She said this is accurate, but it's not the issue at hand. If you go back to the day they argued this at court, and I got it pulled up, I got to see if Miss Abbasi sitting over there. Miss Abbasi said this. She stood up and she said, Judge, I thank her for all of that, but that's not what we're arguing. She said this in court. She said just at least one member committed the crime. Boom, boom, boom. Hold up. Okay. Those cases address who committed the overt act, not whether the indictment included the overt act at all. She said, baby, y'all came with case law, but it's wrong. You came with case law, but it is wrong. Thank you for it, but it's not even arguing the issue at hand. And that's the problem. Miss Abbasi said, go back, sit down, and try again, because this is not it. A valid indictment must include all of the essential elements of a crime. A RICO conviction requires 2 steps: proving a defendant has committed 2 or more offenses or the sorts included in the RICO statute, and proving the offenses have been committed as part of a pattern of racketeering activity. She gives the case law. With conspiracy to commit RICO, the first requirement no longer applies. Instead, the state must prove the defendant joined a conspiracy in which some members performed the second requirement. While the defendant's degree of participation is lessened, the underlying acts must still be specified. The present indictment meets the first requirement by listing 191 overt acts which allegedly constitute an offense within the RICO statute. If none of these overt acts are proven, there can be no conviction. So did you guys hear that? Did y'all hear that? She said that if they don't prove any of the overt acts, there'll be no conviction for the RICO acts. That's what she's saying right here. Okay. Hold on, let's go back. This is good, y'all. This is good. Okay. She said, if none of the overt acts are proven, there can be no conviction. If the state would like to add to its list of 191 overt acts to satisfy the required elements, the form for doing so is before the grand jury. So she said, if the 191 acts, as if that's not enough already. If they want to add more, go do it the right way. Go get a grand jury and get an indictment. You don't get to use this case to just add things on. Go do it the right way, is what Miss Abbasi is saying. She said, form for doing so, go get your grand jury, not mid-trial. Permitting acts outside of the indictment to support a conviction would amend the indictment. And then she goes with E. This court cannot authorize a jury to convict for conduct outside of its indictment. Who is she talking to right now, y'all? She's talking to Big Page. She is talking to Paige, and she told Paige, she said, listen, I done touched on the state. Now let me go to you. You cannot have a jury convict these young men for crimes not in the indictment. Now she's turned to Paige, okay? She said this court would be required to instruct the jury what the state must prove. These instructions must limit the jury's consideration to the elements of the offense as charged in the indictment. She gives the case law. She says, where RICO could be committed in multiple ways, the instructions are still limited to those in the indictment. She gives more. Okay, that was quick and short. She just basically said, Paige, you have to tell the jury how they have to decide this case. And when you do so, it must only be for things in the indictment. Okay. She said only for things in this indictment. F, the state has proved no authority to support their contention that the indictment needs not include the overt act to sustain the conviction. The state provided to this court A list of cases which include the phrase that the indictment need not set forth the overt acts. Y'all, she back on Miss Love now. She said, thank you, Paige. Back to you, Miss Love. Miss Love was saying this in court too when she was trying to argue this. She said, however, that is not the holding of the cases cited. Oh my God, y'all. Again, she says, thank y'all for the case law, but you're wrong again. The relevant issue is whether the indictment meets the constitutional due process requirements. The state cites this Nordahl versus the state, which indeed does say that the state need not prove the overt act in the overt act in the indictment. However, the Georgia Supreme cites the United States versus Kaplan, which clarifies that an overt act besides those specifically named need be encompassed in the indictment to the extent that the defendant was on notice that those acts would be offered against him as proof of the indicted offense. She's saying again, thank y'all for the case law, but y'all probably didn't read the whole case, because that case is also saying that the charges need to be in the indictment so that the defendant knows that you guys are going to be offering proof within the case regarding that particular act. Miss Abbasi, so she's talking about that. Hold on, let's go. The Second Circuit went on to further clarify that reliance on uncharged acts can amount to a constructive amendment or variance, which would reverse the conviction. Gives more case law. The indictment charged Kaplan with false statements based on representations he made to the FBI during a post-arrest interview and identified specified portions of that statement. In closing, the government asserted that Kaplan's statement contains 7 misrepresentations, only one which has been specifically identified in the indictment. Kaplan, the indictment sufficiently informed Kaplan that of what he said during a specifically identified conversation formed the overt act towards the false statement charge. Additional content from the same conversation was no surprise. Here, the state urges this court to read a single sentence as, is it carte blanche? Blessing to permit conviction based on whatever overt acts the state comes up with. Neither the defendant nor this court can determine right now whether these overt acts amount to amendment or, hold on, did it just jump? Amendment or variance, because those are post-conviction inquiries, and the uncharged overt acts have not been identified. State provided the case United First Jimenez, relying on, I remember Ms. Love saying this. Y'all, she said relying on out of context, the phrase that evidence is not limited to the overt acts in the indictment. United States versus Jimenez. This is true. When examining the sufficiency of the evidence presented, Jimenez was charged with conspiracy to commit money laundering by committing fraud under Gives the Law, which involves immigration documents. On appeal, he argued that specific documents listed in the overt acts would not constitute a violation of the law. Thus, the evidence was insufficient. So they're saying that the court found the indictment did name specific documents which supported false statements. When reviewing sufficiency, the court looks at all the evidence presented, and she gives Super 1194. The issue here in this case, y'all, is not sufficiency of the evidence. It is the due process requirement that Ryan be apprised of the conduct given to rise the indictment. Jimenez did not, nor could he argue that the indictment did not include the conduct which constituted a crime. The documents which support a conviction were specifically included in the indictment. Jimenez had ample notice to the evidence he would need to confront. Do you see where she's going here? Miss Abbasi is saying that in this case, this man tried to argue, hey, every piece of evidence wasn't included in this. In this indictment. However, when you look through his information, they're saying everything that the state he knew everything they were going to present during his trial. When we look at what Mr. Ryan is having, when they got the indictment, they got discovery, we were preparing. This is what we knew that you were going to be charged with. However, now the state is trying to come in and add on. This is not what we were told we'd have to confront. This is not what we told we'd have to deal with. How can we prepare when we're mid-trial and you're trying to add things on? This is definitely a due process issue, which violates your constitutional rights, is what Ms. Abbasi is saying from citing these cases. The state provides to this court a number of cases from the Supreme Court of the United States in the state of Georgia, which hold that due process requires the indictment to provide specific information about the conduct at issue. She cites the cases. Give me just a second. These cases, not only contradict the state's claim that they need not prove the overt acts listed, but instead support Ryan's position that the indictment specified the overt acts at issue. Why she got to eat them up like this, y'all? Why did she eat them up? She said, thank you. The state has proved my case. Everything they used in response to my argument is actually in support of my argument. How can you be this crazy? Are they not reading all the case law? What's going on? Miss Abbasi is saying, thank you. Everything they submitted is not doing anything, but they're not doing anything but agreeing with my argument. Miss Abbasi, she represents Rondelius Ryan. She's one of the attorneys that help represent him. She says the state's contention. This is her conclusion, guys. The state's contention that overt acts solely outside of the indictment not only ignores the law, but also offends a fundamental notion of fairness. The state has no reason to argue that overt acts outside of the indictment alone will sustain a conviction, unless they need to rely on this premise. Yeah, I don't think she's African American. Miss Abbasi just said, let me read that one more time. I'm just going to read the end, guys. Okay. I had to make sure. Let me make sure I was making my point right. She said the state has no reason to try to come up and rely on overt acts not even mentioned in this indictment unless they have to. What she say, Key? Why would y'all want to rely on overt acts that are not in the indictment unless that's the only thing y'all can rely on? Wow, y'all know one of the overt acts was when they had the little incident in the jail where there are probably cameras. There's probably no doubt you can kind of prove he did all of the. Why would she have to rely on those things, guys? She said, unless you have to. You might have to rely. She said that's the only logical reason I have for you trying to pull overt acts mid-trial. This must be the only thing you can rely on. Okay. She said the state would only need to make this change if, as the trial progresses, it becomes evident that the state cannot prove its case. Period, Miss Abbasi. What did Paige tell them yesterday? Miss Page has said I think they're winning. You're unorganized. You're trying this case as you go. You're making this case hard for everyone involved. I don't think they have strong evidence that these young men were selling drugs so that they can benefit some in furtherance of anything. But hey, I'm not the jury, is what Paige said. The state, this is my favorite line because I say this all the time. The state has a duty to pursue justice, not a conviction. As the state watches their case. Yo, she said, as the state watches their case fail. Oh, I gotta go holler at Miss Abbasi on Twitter. As the state watches their case fail, they refuse to accept the possibility of defeat fair and square. Miss Abbasi said, listen, y'all, we beat you fair and square. She said, as the state watches their case fail, they refuse to accept defeat. Fair and square. But rather seek to make up a new case as they go along. She said they know they're not winning on these 191 overt acts. So they want to pull 192 and pray they can win 192. She said they pray they can keep 192. No defendant can prepare to defend against allegations which are being invented as the trial goes along. Such a demand would render due process meaningless. However, that seems to be the door the state wants to keep open throughout this trial. Baby, she just called their whole case meaningless. Baby, Shay, she done drug her by them slingbacks. Drug her by them slingbacks, Shay. She said, however, that seems to be the door the state wants to keep open throughout this trial. If these overt acts aren't working, just add some new ones. If we can't get them on these 191 overt acts, let's just add some new ones. She said, just add some new ones on there. And then she closes and she said, this is neither legal nor just. Respectfully. Miss Abbasi, it wasn't nothing respectful about this. I just want to tell you that, Miss Abbasi, there was nothing respectful about this motion. Y'all, this was, I can only pray to write as beautiful as Miss Abbasi wrote here. Oh, God. Let me see if it started. Because we wanted to get, y'all told me it was day 114. Let me see. Does Miss Abbasi, this might, y'all right. I see Miss Abbasi in court. Miss Love got her hair wrapped up. Oh, y'all, we gonna have to find it. That what y'all, what they say, she did her big one. She did her big one. It was beautiful. Come on, give me one word, guys. One word in the chat that describes what we just read. One, I just can't believe instituting was kicking my ass like that, y'all. I don't know why I was saying an R in that word, so I apologize. I'm gonna make sure I proofread, but this was my first time reading this whole motion. Baby, that motion, 4 + 4, I know that's right, Star. Demure, okay, savage, truthful, amazing. I was thinking of that too, North Philly. Astonishing. Yes, I like that, Miss T. Classy. I love that too. Real. Love that one. Let me see his. Hold on. Between the case law. Oh, y'all, the case law. K-Neek. K-Neek. Factual. Love that one, Cass. Wait, Shay. You thought that was inartful? You know that's Miss Love's word when she does something wrong. Star! Why would you do that? Star! Oh my God. Yeah, I'm pulling it up because I want you guys to hear her argue this. But I'm going through the she talks about it. I'm going through the I'm trying to see when she stands up. Because she argues this in court. I'm looking for it for you guys. So we can you can hear her argue this. So I'm having a look to see when she stand up. It was after lunch. I do remember that. But I thought she was standing to the side when they argued this. Paula, I went to Kingsbury too. I graduated from Kingsbury. Somebody need to cash out love. Cass said vehemently. I graduated from Kingsbury, Paula. I went to Kingsbury and Craigmont my senior year. She was on the side. I thought so. North Philly. I thought this particular argument, she was sitting where Mr. Matthews was. But I could be wrong. It could have been here. Oh, this might be it, y'all. Let's see. Let's watch a little bit. We're going to see. This is Max. Hold up. Okay, y'all. Let's see. Okay, y'all. We're going to see Mel with this Miss Love will be so mad. Listen, Ariel, I know Miss Love got to be pissed. Oh my God. This had to upset Miss Love. Okay, guys, let's see. Now I don't know if this is the exact argument, you guys, but this is definitely Miss Abbasi. I know there were 2 days, but this time this is one of her arguments.
Mr. Ryan, Mr. Blaylock, and others, as well as the violation of the Georgia Controlled Substances Act by Mr. Williams and Mr. Adams. And those two occurred on January 31st, 2023 and January 18th, 2023, respectively. The filing that we noticed the defendants of those on was November 6th, 2023. There were two additional acts that occurred in 2023 during the time that this case has been ongoing. And one was the drugs that were found in Mr. Stillwell's cell. And we've noticed some of the pictures of the drugs and the other contraband.
I'm going to pause this. North Philly, I was texting you, but it's too much to type. North Philly, this is that first time. And then she has to come back with case law. So I don't know. So to give you guys some context, when Paige started court and she was like, I'm standing on my ruling for this. This is going to stand. I'm not going to allow this. When it came to the overt acts Miss Love was trying to add, this is some of that. Now, the Rodelius Ryan one, I think it's the one where they jumped someone for taking his commissary or something. That one is still outstanding. But what you guys are going to see is like the argument whether we should add, like Shannon, when they found the parentheses in his cell. That's what we're watching, so that you guys get so that you have some context. But Miss Abbasi is going to argue here. this was the first time, and then there's going to be a second time, which I'll have to find. There's a second time she argues this as well. I want to make sure you guys had context.
And the marijuana that was found in Mr. Ryan's pants when he was searched in the courtroom.
Mm-hmm. Okay, so the stabbing that occurred in the jail, right? Okay, and then the VGCSA violation was in court.
It was.
Obviously drugs in Mr. Stillwell's cell was in jail, right? And then the marijuana in Ryan's pants was in court. Is there another incident that occurred in court?
Not that's on here.
Okay. Ms. Abbasi, you had said 1 in jail, 3 in court.
I'm sorry, Judge. That's
2 in jail, 2 in court. Okay. Okay. And the argument as to each is that this is not really intrinsic?
yes, Judge.
Okay.
It doesn't fall into any of the 3 categories which would classify it or qualify it as intrinsic.
Okay.
Here it is.
Let me pull out my case law on that. Which
This was good, y'all.
all right. What's the state's position on why and how that is intrinsic?
The Bussy stabbing, which is the one I'll start with, Your Honor, involved
I'm
YSL.
sorry, what'd you say? The what?
Oh, I'm so sorry.
I just didn't understand what you said.
Understood. The victim in the January 31st stabbing, his name is
Okay.
Harold
All right.
Bussy, and that's what
Bussy,
I refer to it as. So that stabbing involved several YSL gang members stabbing an inmate at the Fulton County Jail who was alleged to have messed with Rodelius Ryan's commissary. It involved, among others, Demise McMullen, Javon Fleetwood, Christian Eppinger, Damone Blaylock, and Rodelius Ryan. They all, in concert, held down this person and stabbed him repeatedly, all to protect and to vindicate something he had done to one of their fellow YSL gang members. Is the way that I see it. So that it seems just it's what we've alleged in the indictment that YSL members do. They work to maintain individuals ready and willing to preserve and protect the reputation, power, and even the territory of the enterprise through the use of violence.
Okay, I understand.
With respect to the law, we would cite Johnson versus the State of Georgia Supreme Court case decided September 21st, 2021, cite 312 Georgia 481. And we cited this last week. The Penn site is for.
Just to let y'all know, all of these cases that she's citing in court, I'm typing them. They're also in Ms. Abbasi's response.
The Penn site is 491 to 492. In support of it. Okay. With respect to the January 18th violation of the Georgia Controlled Substances Act, this is 2 YSL members on trial for conspiracy to violate the RICO Act through drug distributions, drug use, drug possessions. And while in court on trial, they are passing Percocets one to another. And we argue one to the alleged leader of YSL.
Okay, for you, those of you who don't know, there was an incident in court, and they're gonna play it where someone just walks up to Thug and puts something in his hand. The guard sees it, and they see that it's a I don't want to say the word on here. It's a parentheses, okay, and that is what Miss Love is talking about here. When she says they're giving it to the leader, she's. I think she really over-exaggerated this. Like, it didn't look like Thug knew that's what it was. The person just literally walked up and put it in his hand.
Out in open court. One of the
Thank you, Key.
assertions that we make regarding the conspiracy. We have contraband in the jail. We have stabbing in the jail of YFN Lucci. We have communications in the jail. These types of actions on the part of the defendants are the type of actions that we have alleged in the indictment, and it shows that the enterprise flows from the streets to the jail to the courtroom, and that the conspiracy is ongoing.
And what exactly is the evidence you would be introducing on this VGCSA?
The video of it.
And what all does, I mean, maybe I need
The
to,
video
what does it show?
shows Mr. Adams going up to Mr. Williams while on a break. He's appearing to dap him up, if you will. Mr. Williams puts his hand up under the table. One of our lieutenants goes over to Mr. Williams and sort of says, "Give it here." Mr. Williams brings his hand out from under the table, relinquishes the Percocet to him. And later, Mr. Adams is searched. And I think more Percocet pills, more drugs are found on Mr. Adams. And the drugs, the photos and
Okay,
Y'all heard her calling my man. Y'all
tests
heard
of
about my
those
man.
drugs.
all right. What's next?
The marijuana was also, so in Mr. Stillwell's cell, there was, on March the 29th of 2023, there were drugs found in Mr. Stillwell's cell that consisted of ecstasy pills,
Oh, yeah, I'm sorry. Miss
contraband,
Love, slow.
a contraband cell phone, for him to have gotten those
Okay.
drugs into the jail while he's on trial for
Y'all must speed up just a little bit.
Okay.
kind of actions involving narcotics
I had
and
to
the
speed up.
enterprise and the sale and distribution of drugs through that enterprise.
Yes, crime nerd.
We believe is evidence of the ongoing conspiracy.
Okay.
Another,
And then the last one, I guess, was the marijuana found on Mr. Ryan. Give me a little bit more background about what your evidence is going to show on that one.
that Mr. Ryan, while sitting in court, I believe deputies may have smelled the marijuana
Okay.
on Mr. Ryan. And when they went back to try and search or to figure out where the smell was coming from, a large commotion was made. And the deputy,
By a large commotion by,
Mr. Ryan, and the deputies found the marijuana attached to, I think, his inner garments.
okay.
We have the video.
Okay, we don't know how it got there.
Um,
I mean, on the Percocet, you've got an alleged gang member providing it, right?
Yes.
Mhm.
So how about, we don't have anything like that with regard to the marijuana?
We don't have,
We
we
just-
provided him with the marijuana, no.
Okay. All right.
Did y'all hear Paige? Paige said, "Do you have it or not?" And Miss Love laughed. She's like, Miss Paige wasn't laughing. You don't know how it got there, so you can't complete the story.
I don't know how pertinent it is that we have one that's not on here that is also involving drugs that are brought into the courtroom and provided to another YSL member, but that particular one has been severed, so we don't have that one
Right.
on here.
Okay. I think that the first three that we talked about are, I can see how those would be intrinsic to showing the allegations that, this is a continuing, ongoing RICO enterprise. Mr. Ryan being in possession of marijuana when we don't know where it came from, that one, I just don't see that falling within. I mean, it shows, what it shows, that he's in possession of an illegal substance, but it doesn't, I don't think it's intrinsic. So I'm going to rule that one out.
Yes, Your Honor.
The other three,
Your Honor,
yes. Go ahead.
I appreciate the directed verdict that you just gave for one of Mr. Ryan's.
Oh, is that
intrinsics.
one of his? That's not something.
No.
Yeah.
I'm saying you're
That's
keeping
not
it out
anything
without
that-
hearing, but from us. But regarding Mr. Stillwell's,
Mhm.
okay, we have an indictment with 100. I believe it's 191. Could be off 191 over X.
Yeah.
Okay. We also now have a list. At first we thought maybe they had abandoned these 53 and they were narrowing it down to 4, but no, it's 53 plus 4, 57 plus 191. That's 248, I believe. 248 uncharged events, or not substantively charged events in that are coming into this trial. Regarding, the state keeps saying, and this shows the enterprise. Okay, there were apparently, I've seen photos, I wasn't there. There were pills that were recovered from Mr. Stillwell's cell, where he has a cellmate. Okay. There is absolutely nothing about those pills that suggest they were provided by anyone associated with YSL. There's absolutely nothing that suggests that those pills were going to anyone associated with YSL. There's absolutely nothing to suggest that any proceeds from those pills were being provided to anyone in YSL. There was a phone. I have not received any information from that phone that suggests any link at all to YSL. I am not saying my client's a drug dealer, but what I am saying is people that are in possession of drugs, whether it be my client or his cellmate or someone else, are able to sell drugs without being part of a huge enterprise. And without any evidence that somehow this is linked to YSL, this isn't intrinsic. The test for intrinsic is an uncharged offense arising out of the same transaction as a charged offenses. I don't believe that's the case. Evidence necessary to complete a story of the crime. That is definitely not the case in this scenario. And it's inextricably intertwined with the evidence for the charged offense. I don't believe that's the case either. So
Well,
I don't know why this
I
is.
understand. Thank you
And,
for.
and just so you know, Your Honor, he is charged on a separate indictment. I believe it's indicted. If not, it's in a CP case still.
Do y'all need me to slow Max down? Because Max does talk fast. I forgot I sped it up. Do y'all need me to slow Max down, or are you guys cool? It wasn't until right here, y'all. I said, damn, he talking fast. Excuse me, but do you guys need me to slow him down? Okay, y'all good? Okay. Isis, it wasn't until this just now. I said, damn, he talking fast.
But he is charged separately. In that case, is pending in Fulton County Superior Court.
Okay, appreciate it. Thank you for bringing my attention to that.
Your Honor,
Yeah.
if I may a bit further, the one case
On which?
really regarding all three of them. I'll
Okay.
start specifically with the stabbing as the state did.
Can I rule on this other one first? Give me just a second.
Which other one?
The one that Mr. Sharp
Oh,
was
yes,
just
yes,
talking
Your Honor.
about. Okay. So the Stillwell had a cellmate. Is there any evidence as to where the drugs came from, or that it was his, or that the cell phone was his, or connected in any way to YSL?
So yes, we believe that. I think we have to do a body research.
She
We
finna
believe
get
that the
ready to
testimony from the deputies within the jail would establish his ownership of it. But more importantly, what we have, I briefly touched on it, was the other YSL member whose intrinsic act that we've not put in here. The pills
Mhm.
If we call them purple hearts, blue stars, and yellow diamonds, they were trafficking amounts in Mr. Stillwell's possession, and they were trafficking amounts in the other YSL members' possession that is not on here and that has been severed. They are the same type of pills, and they are a large trafficking amount.
Okay.
So if we all, she's basically saying that this was an enterprise because they're in jail selling the same type of narcotics. First of all, they're in jail. I would imagine that it's hard to smuggle stuff in, right? So anybody in that jail who traffics will probably have stuff from the same bunch. Simply because you're in there. Most of the product, it's not easy to get in there. But this is how she based her case.
But
and we know that at least that other one, that other YSL member smuggled the drugs into the jail.
How?
Or at least into that area through the courtroom. As it was described, it was enough in one, it was a pharmaceutical.
okay, so any evidence that what was in Mr. Stillwell's cell came from that?
Other than it was that they were just alike. If you looked at photographs of it's not like you had all white pills. Like you had the same array,
Blue, purple, and
to use just some colors. Like they were literally at least three different colors and three different shapes of pills. And they were the same, three different colors and three different shapes.
And you can establish that those were YSL related?
Yes, because the
how?
when you say those, you're talking about the one.
So if I'm to accept that y'all have enough that you can make the assertion that the pills that came through some court proceeding to this other person who's not a part of this trial, are the same that are in Mr. Stillwell's cell, then what's the YSL connection?
Not the same pills, the same
type, the same, shipment or whatever, the same.
That person was in this trial. That person was in this trial during that time.
Okay, but them being in the trial and co-defendants doesn't establish what the assertions are.
Come on.
No, it's the not similarities, the exactness of the like.
No, I'm not asking at this point, like assuming for the sake of argument that, yeah, these pills all came from the same place. And he, in fact, then what's the YSL tie-in?
Yes.
Maybe approach with a member of the defense.
Sure.
Okay, yeah, let's get this.
So we can hear what's going on.
I didn't know y'all didn't have them. They're not up here. Oh, yes, you may.
Thank you.
Guard said those three circumstances. Uncharged offense, which arose from the same transaction or series of transactions as the charged offense. That's actually the topic of discussion in Brown. And in Brown, it was a robbery which happened 1 hour before the charged crime. If the state is going with it's part of the same transaction or series of transactions, then we have a very serious problem with proximity, because the case law is not anything a conspiracy does that happens over the lifetime of the conspiracy qualifies as intrinsic. It has to be closely linked with the others, closely linked with the other charged offenses within the indictment. Your Honor can look at Sanchez Villa versus State, just 341 Georgia App 264 from 2017. Within that case, the evidence the state was trying to present, the court found all of the cases.
Ow! I'm sorry. Y'all look at D. Williams. D. Williams looking at her like, girl, where you get that from? Look at D. Williams looking at Miss Abbasi. She looking like, hold on. Look at how she looking at her when she's reading, y'all.
Cases that are distinguished, either a RICO charge that was involved or a gang enterprise.
I will double check because they go through quite a few cases. I'm going to have to look back through all of them. I think the hallmark of it that we get within Sanchez after they discuss all these cases, the evidence in this case, the Sanchez case, is considerably more attenuated in time and space from the events leading up to the charge offense. So it offers little to help the state. They continue on and say that, well, as far as this goes, we're not in a circumstance of completing the story of the crime. This is just expanding it.
Yeah, I mean,
completely.
right, it's a different crime.
Okay, guys, what Ms. Abbasi is explaining here is we're talking about intrinsic acts. She's talking about what constitutes an intrinsic act according to the law. She's talking about space and time and how you can say something is intrinsic if it is within a certain amount of time and space to the original crime. What she is arguing is that we are 2 years removed from the indictment. So that space and time is gone. She's saying an intrinsic act, it completes the story. It adds to the story in some way. She said that's not what the state is doing here. They're just trying to, I think she said they're prolonging the story. Let me rewind it for you guys, but listen to what she said about the story. I'm gonna go back just a little bit so you can, I want y'all to hear that last part.
64 from 2017. Within that case, the evidence the state was trying to present, the court found all of the cases the state submitted distinguishable. And the same is true here when Your Honor goes through the cases.
Okay.
As far as being part of the same transaction or series of transaction as the charged offenses. This, like those cases, is attenuated in time. For ones which do have more time in between, they discuss how in those cases, the defendants in their other uncharged acts were in the exact same role. So in one, it was trafficking cocaine as a lookout. In the uncharged, trafficking cocaine as a lookout. There were very specifics linking them.
Were any of these in the Sanchez via either those facts or the cases that are distinguished, either a RICO charge that was involved or a gang enterprise?
I will double check because they go through quite a few cases. I'm going to have to look back through all of them. I think the hallmark of it that we get within Sanchez after they discuss all these cases, the evidence in this case, the Sanchez case, is considerably more attenuated in time and space from the events leading up to the charge offense. Mm-hmm. So it offers little to help the state. They continue on and say that, well, as far as this goes, we're not in a circumstance of completing the story of the crime. This is just expanding it.
Yeah, I mean, right, it's a different crime, but it might have been a different thing if they were charged with a RICO count in Sanchez. So that to me is what, if these were just whatever the other charges in the indictment are, then I would say, no, but it's the kind of enterprise nature and the ongoing nature that.
And I certainly.
And Paige is telling Ms. Abbasi, oh, I hear you there, but is that a RICO case you're looking at? Because, when you're looking at a RICO, I think it's a little different because in the RICO, there's an enterprise. It's not just one person. It's, an enterprise. And in Georgia, y'all could be one person. So Paige is giving her pushback, but she gonna stand on 10 about it.
I understand that, Your Honor. I think, however, to say, well, it's part of the conspiracy basically opens the door to anything, any defendant allegedly who is a member of YSL does, then automatically becomes part of the conspiracy and automatically comes in simply because it is intrinsic. Okay. I think with a lot of this, Your Honor, we're getting close to some due process concerns here. The defendants are on trial for the offenses they were indicted of. That's what they're on trial for. They're not in trial for the enterprise continuing in 2023, that it was still ongoing. That's just not relevant. If the day after indictment, every one of the defendants got together and said, whatever our group is over, and it was completely disbanded and no longer continued to exist. That wouldn't be relevant either. What they're indicted for is what they're on trial for. So here we're expanding. That's, I think, a lot of what's happening with our social media and other things that I guess the state has found afterwards. They're now being tried for things the grand jury never heard about. And that specifically is a violation of due process. I can supply to Your Honor the U.S. Supreme Court case law.
No, I'm with you on that one. And I am very skeptical of the state's argument that any uncharged, not showing up in the indictment overt act that they offer could in any way support, if found, a RICO count being established. So unless I hear otherwise, which I don't want to hear otherwise right now, we'll take that up another day, but that's not our issue right now. But yeah, I think the state's got some convincing on that count. But with regard to whether, it's intrinsic, I want to get it right. I want to follow what the law says about it. So I think that the key issue here is if we're talking about RICO or we're talking about, a gang enterprise kind of thing. So maybe we could all do a little bit more research on that.
I did look at in the state's original notice, they cited a proposition, I believe that was cases have been in gang and conspiracy prosecutions, gang and conspiratorial activities have been classified as intrinsic evidence. They then cited a number of other cases. There is not one single case I can find in any case at all where the intrinsic actions come after the indictment, because that's the touchstone of it being intrinsic, that it really is all one thing, that the story doesn't make sense without all of these pieces. And these things hadn't even happened yet. So it's not possible that they could be essential.
Let me ask you this. If, for instance, and this is entirely a hypothetical, but if this group got together and stabbed this, whatever his name is, Bussy, not because he messed with Mr. Ryan's commissary account, but because he was going to be a key witness in this case. And I'm sure the state, if in this hypothetical, would argue we're trying to send a message that he better not be a key witness in this case. Would the argument be different then?
Well, yes, they wouldn't be trying to admit it as an intrinsic act. It could be a crime in and of itself separately.
No, we're not talking about then they get separately indicted. We're talking about they're in the middle of this trial. This happens. It's not obviously set forth in the indictment because it just happened.
Okay, I'm gonna stop just to say I didn't really like this from Paige because it felt like she was giving her pushback. My girl came up there with case law. She wasn't just talking. She came with case law. Then Paige started throwing hypotheticals. But then again, y'all, it could be the appellate attorney in Paige that wanted to see where her head was at. I don't know. But this little back and forth, like from Paige, kind of rubbed me the wrong way.
It would be 404B and probably fall into a category there, which would make it admissible for a basis which was not character. It just wouldn't come in as under intrinsic.
Okay, so you would still make the same argument that it couldn't be intrinsic evidence, even for that, because it occurred afterwards.
Based on the definition I've seen of intrinsic, I don't think it's possible for something which comes after to be necessary to complete the story, unless the story wasn't complete at the time of indictment. That's fundamentally unfair to try them for something which hasn't happened.
Okay, they're not being tried for it. Okay.
Based on
all right. Well, I mean, y'all try to find me some more on-point law on both sides, please, if you could. So maybe that'll be my preliminary ruling, subject to revisiting. Okay.
And Judge, there was one other thing. I don't know that it'll have any bearing on the court's ruling, but in that instance where Mr. Stillwell, where the drugs were found in Mr. Stillwell's cell, there were Miss Hilton pulled up the photograph that I asked her to, and there was a shank.
Yeah, this is my favorite part.
Shank inscribed YSL. Then
No.
it doesn't. I mean, it makes Mr. Stillwell look bad, but it's not intrinsic.
Yes.
Okay.
Your Honor,
Yes.
if I may.
Yeah. Paige said it's the shank inscribed with YSL because y'all they saw they were losing. Paige came back. Is it inscribed YSL? Then no, hang it up. Y'all, I remember I cried so hard off that.
Before you make a decision on the one alleged intrinsic act that was referenced by the state involving the supposed passing of a Percocet pill from Mr. Khalif Adams to Mr. Williams, I would ask that the court at least go and take a look at the video that was referenced by the state. I think it's instructive. I also think that well, fortunately for us, paints a different picture than was recited by Madam Prosecutor. I think the events did not occur in the manner that she referenced. I was present. I was sitting right next to Mr. Williams. I think the video will show something being passed to Mr. Williams, not him hiding his hand underneath the table or bringing it out and then giving it to the deputy, or the deputy saying, give it here. It didn't happen that way. And I think that goes into the analysis of exactly what happened.
All right, why don't you just tell me what you recall or what you think the video shows?
Sure. What I recall, what I know happened, because I was sitting right next to Mr. Williams in the front of the courtroom, is that it was a break. Mr. Adams, who was sitting in the rear part of the courtroom, came up, and as he was going towards that door, goes as though he's going to give Mr. Williams a high five or a dap or something like that, and put something in his hand. There's a deputy who's standing about 2 feet in front of Mr. Williams. Mr. Williams looks surprised. Mr. Williams has it in his hand and puts it down on the table immediately. There is no putting hand under the table to try and conceal it. The deputy, who I was within earshot of, did not say, give it here. Mr. Williams looks at it and puts it down on the table, and that's it. Okay. At which point, another deputy sees Mr. Adams and either takes him. I don't remember if they took him in the back or brought him back here. Okay. He was searched in the back, as I understand it. I think court recessed after that because of those occurrences. But that's how the incident actually occurred.
Okay. Can y'all send me that video?
Yes. And,
okay.
And the lieutenant would also be a witness to what I'm saying.
All right, well, I mean,
The version
I would
I'm reading.
imagine the video shows what happened. So.
It does.
It does indeed speak for
All right,
itself.
well, we'll come back to those two.
Well, yeah, I know that when they played the video,
All right, so that takes care of the allegedly intrinsic, but according to the defense, can't be intrinsic because they happened later in time than the indictment acts. What about the other intrinsic or allegedly intrinsic acts that there has not been a 403 analysis on yet?
Can I just add something to the last? Your Honor, can you ask what the prosecutorial need for this is?
come on.
I can't,
Right.
but with intrinsic acts, that's not part of the analysis.
Yes, 403 is the
Well,
analysis,
403,
which
So-
includes prosecutorial need, waste of time, prejudice, substantial prejudice outweighs any probative value. But to me, this is a big case. It's
It
been going on a
is.
long time, and now intrinsic acts. So yes, I
Okay.
don't know how much the state needs to prove that Mr. Williams
Exactly.
was knowingly or unknowingly given an alleged item. I'm not so sure the crime lab came back, but I can't answer for that.
has the crime lab come back?
That may be true. I don't know. I don't remember.
Okay. All right, so we now have a 403 argument or objection.
So, Your Honor, I think that the court had it right regarding the need to analyze, looking at the prosecutorial need. If it's a 404B act, then that would be a situation where we would be looking at the prosecutorial need, but it's not. We're alleging that it's an intrinsic act, and looking at 403, Your Honor, the analysis is it substantially more prejudicial than probative? And it's simply not, is our position. He's alleged to have, Mr. Williams and the other indictees here are alleged to have conducted drug transactions. One of the acts on the indictment involves
Them having a trafficking amount of drugs, right?
at least one. So we would argue that it in no way can be viewed as substantially more prejudicial than probative, and it's intrinsic. But we're pulling up the video too.
Well, I mean, I guess is it intrinsic is yet to be determined based on the time period, but
Yes, Sherry Ann.
Your Honor, this
Yes.
is not really my argument, but I have got to weigh in here
Oh,
on
please
this
do.
issue. Yeah, thank you. I'll get my 5 minutes in. The 403 analysis is not limited, as you know, to is it more prejudicial than probative. As Mr. Steele said, you also have undue delay and waste of time, and those are factors as well that I'm not surprised that the state ignores because they seem to have no concern for delay or waste of time. So those are factors that the court should consider as well, Your Honor.
Doug!
thank you. Okay, well, I will give y'all a couple of days to, if you can find more on point law, provide that. And
Doug,
if
you
not, I'll
never
just have to
would have-
go on what we've got and make a decision. I'll take a look at the case that got cited and the cases within that. And then if need be, do the 403 analysis. We'll
Doug
get to
said
that.
he's not surprised they want to waste time.
So, that's those. What about the other intrinsic acts that 403 hasn't been done on yet? Do y'all is there a list? And is it? And I can't, let me see, I'm not sure quite who filed that one. Or maybe Mr. Sharp just told me there are some that the 403 hasn't been done on yet. From the November 6, 2023 filing, but I don't know which of those.
And some of them have already been, so Judge Granville made an initial ruling
Right.
on one day on 1 through 3. And then throughout the trial, we dealt with and admitted evidence on number 4. Does the court?
Not
have a
right in
list?
front of me.
What list you're referring to?
The
Is it-
filing on November the 6th,
Girl, she turned
2023.
around. Look at that.
Yeah, I think
Of
I've
the-
got that.
Y'all, this lady is crazy. Hold on, y'all. Let me see.
Okay, yep, I've got it.
So, Your Honor, my recollection is that we began discussions on this one day a long time ago.
Okay,
And I agree with the state that they have presented evidence on some of these incidents, some of these acts. Your Honor is saying that we haven't done a 403 analysis. I don't believe we've
Only
done-
because y'all, that's what I thought you had said to me.
Okay, if I said that, I believe I misspoke. I don't believe
Okay.
we've done really any analysis on this list, meaning
Okay.
I don't believe, speaking for the people on this side of the room, I don't believe that we are conceding that they're intrinsic.
All right, so we may need to, starting with number 5.
Okay,
look at all
y'all
of them.
saw her to the
Your
right.
Honor, I thought we were going by the state's July 31st witness list. So that would not encompass all of these things on here. That witness list went through by what offenses it was set to
Oh,
prove. or
this
acts.
one?
Yes. So I was relying on the witness list when filing motions in limine of what they actually intend to prove. I thought that was the whole purpose of.
Well,
Judge, I'm not sure if Ms. Abbasi, we filed this November
Yeah.
6th of 2023, and I know she wasn't here at that time, but we, this is the argument I think that Mr. Sharp made. This is the one that he sent out with his objections. This is the filing. So this is the one that we're addressing.
okay, well, I mean, if for instance, you're not gonna, you don't intend to use, 20 through 30 anymore, tell us that. If you still think you intend to use every one of them, tell us that.
A lot of them have already been completed, and there have
Okay.
been testimony, there's already been
All right.
testimony on a lot of them.
Okay, so can you tell me right now?
Yes.
Which that's true for?
Number 4, the 5/12/2013 aggravated assault and home.
Yeah, I mean, I've got it right in front of me, so if you just want to say number 4, that's fine.
Number 4, number 5.
And you said a ruling had already been made on 1, 2, and 3?
Yes.
Okay.
We didn't admit them, but they were. Okay, so we did not admit evidence of 1, 2, and 3. All that we did was address them initially. We didn't admit evidence, and we don't intend to, but those are the only 3 that were addressed initially.
And you don't intend to, so you're not intending to introduce those 3?
Right.
Okay, well then we'll cross 1 through 3 off the list. Okay, 4 has already been admitted, 5 you said's already been admitted.
Right.
Now what?
Also, as it relates to 7 is one of the overt acts listed. The reason that we included it here is that Shannon Stillwell's name was not in the indictment itself
Okay.
on that overt act. The same as to number 8. What? I said the same as to number 8.
Okay, so those are listed, those acts are listed as overt acts, but Mr. Stillwell is not listed in the indictment. when
Yes.
You're talking about the overt acts. Okay,
Correct.
all right. What about 6?
6, actually, we
Y'all look at Doug Wine.
so 6 is going to be talked about. It has already been talked about some.
I gotta pause. We need to do a check-in. Can somebody tell me where the likes are right now? Thank you guys for watching. If you are just joining us, we're actually just we read Attorney Abbasi's memo, which was chef's kiss. And we're just kind of going back and watching her verbal arguments so that everybody can get a complete understanding of why she presented that memo. Okay, we're doing good on the likes. Thank y'all for messing with me. I can't be acting Memphis on this live because y'all know I want to say something else. But thank y'all so much. So if you're joining, that's what you're watching. We're just on here watching her past arguments and hear Ms. Love stumble over words. That's what we do.
And it'll be talked about some more.
Yeah, I thought it had already been talked about some. So I mean, that's in the past, basically. 7 and 8, given that they're overt acts, adding Mr. Stillwell to them, that can still come in as intrinsic. What else?
10 has already
How about
been.
9?
9 has not been talked about.
And do you intend to still present evidence of that? I mean, you do at some point need to streamline your case.
Here we go. Y'all, this is the beginning of Paige taking over.
We can strike off number 9.
All right.
I believe.
Paige has told her this about 10 times.
10 and 11 have already been alluded to, and in fact, 11 has been discussed by the witness who's currently on
Okay,
the
so
stand.
those are already in.
Yes, and I think that the court at first asked me to tell the court which ones that we.
Well, you know what? Why don't we just walk through them the way we're doing now? You might decide on some other ones that you don't need those.
All right, so Hill Street there will be testimony given on that through Detective Dennis.
Okay. And
Oh,
he's
he already
involved in
talked
that.
about it. Ms. Hilton has
Okay,
reminded
so that's already in also. Okay.
Number 13, a witness has already talked about.
Yep, Eva.
Mr. Copeland on the stand. Number 14 has already been testified about.
Okay.
We've taken off number 15.
Okay.
Number 16 has already been testified about. Number 17 has, we've already presented evidence on.
Okay.
Just so you guys know, Ms. Love is going through intrinsic acts at the current moment. Remember, there are 240. There were 191 when it was originally indicted, and then they added more.
For 18, we've already presented evidence on. Number 19, we intend to present evidence on.
All right, and tell me, is that like part of the gang rivalry leading up to Mr. Thomas's? I mean, I'm just looking at the date for that, or why is that intrinsic? Why is that a part of the whole story?
Already.
We've talked about it, or y'all have talked about it.
She's right. We did.
I'm not aware.
The aggravated assault at Trestle Tree on the 8th.
What case is that?
The aggravated assault at Confederate Court.
I'm aware of that, but
Through Detective Dennis. I believe that when he gave, I'll have to go back and make sure, looking at our, at the flip chart that we made while he was on the stand.
Okay. But would this be part of the back and forth that y'all assert led up to?
It was part of the shootings that they went back after the murder of Donovan Thomas and found out about. So that when we say back and forth that led up to it, they started investigating those shootings after the murder of Donovan Thomas.
Okay.
And this was one of the ones that.
And this is a shooting of whom by whom?
At Trestle Tree, which would have been If-gang territory, we allege by YSL members. But
Okay, and what evidence do you have of that?
we did. Okay. And just so that Mr. Sharp has that, it's for 150080094. We've already put the CAD report in the 911 call in.
okay.
Okay, well, that pretty much sounds like that's in then.
Well, I don't agree. I mean, what's I think obvious right now is I've been very involved in this case.
Mhm.
I don't know what this January 8th shooting is. I'm asking Miss Love. She doesn't know. So I'm trying to figure out how anyone could argue, if no one even knows what it is, how it's so intrinsic to this case.
Yeah, I know if she doesn't know what it is.
Well, I mean, I
period,
can
or if
ask
she
you, I'm
just
giving
doesn't
up.
know right now what it was. So who is alleged to have done this? So, or is this just a general, we, the gang experts, found out about this and we think this was a part of it? So, okay. Is there going to be more besides what's already been testified to? Okay.
No.
So it's already in. Okay.
Okay.
What number?
20.
20. We have already heard testimony on this one.
And that's all we're going to hear as to
Yes.
that? Okay.
Yes. And we've already heard testimony on 21
All right.
and 22.
Mhm.
We're not introducing 23.
Okay.
24, we've already heard testimony about, and we will hear more. This is actually where we got that video from that we mentioned. Mr. Sledge, that's in the folder for Mr. Sledge.
This is going to come, I mean, great if the video happened to be from there, but what else is going to come in about this ag assault criminal damage?
Well,
Come on.
Antrevia Smith is one of the witnesses that we've listed,
Mhm.
and her testimony.
That's a victim?
Yes, that's whose house it was.
Finally, Key.
All right. Okay. Go ahead then. 25.
This is January the 28th. I thought we'd already introduced it.
Chanel talking about anybody heard from Mounk. Chanel, you talk like he in our phone book.
1502.
Okay, yeah, I'm gonna stop this one. Key found the other one for us because if I don't stop this, we'll hear Miss. This is basically Paige trying to see where the state is at It's like a checkup. But yes, Chanel, I don't have, well, I know I don't have his number. I'm joking though, Chanel. I don't have his number or anything, but I was going to reach out to him on TikTok once I got done off live just to check in on him. Yes, Key. I'm not being messy. Key, finally, is exactly what I said, friend. What they be saying, I said what I said. Yes, finally. Okay, let's go. All right, y'all. Key found the second day Miss Abbasi was arguing in court. Shout out to Key. So
yes, Minister Williams' email from a long time ago about all of the exhibits.
Yes, Your Honor, and
okay,
I'll
so
get with
y'all will
Ms.
get
Abbasi
together on that.
Yes, to discuss a time.
Okay, and can you remind me, did the state decide that y'all can, I guess, concede that Mr. Ryan's statement to police is inadmissible, or no?
Yes, we can use that.
Yeah.
Okay, all right. I thought y'all had conceded that, but I hadn't written it down on this. So. Put that in the issues that have been dealt with folder.
Okay, I'm gonna fast forward. Yeah, I'm gonna get off live. It's 4, so it's 5:53. I'm gonna get off live at 6:15 Eastern because I'm doing a quick TikTok live with one of my friends that's a therapist. Just to come on and talk to my followers about this is probably the craziest day because the comments are probably going to be flooded with what's going on with Mounk, all this type of stuff. But she's a therapist, just going to come on and talk about therapy, choosing the right therapist, and just your healing journey. Of course, I had no clue this would pop off. But we're still going to do the live, and for those of you on here that want to come, please join us over there. And we're going to be there in a little bit.
We could talk about the lessons that
The what?
one of the matters that were addressed in an email by Mr. Ryan's counsel was the Harold Bussey stabbing. I believe Mr. Abbasi or Mr. Williams moved in limine regarding excluding the evidence that Mr. Bussey was stabbed. Our argument about it being intrinsic, the court last said or gave Ms. Abbasi an opportunity to give case law stating that things that were used after the fact, Ms. Abbasi can correct me where I'm wrong, but acts that occurred after indictment could not be presented. And I think in her brief, she indicated that, I don't want to speak for her, but I think she indicated that she found no case law in support of that position. So we're prepared to argue
Okay.
that. I'll let her speak.
Yeah, we submitted a brief and went through each of the possible admissible purposes. And as far as continuing the story, something which happened after the indictment is all in there. However, something which after indictment certainly could be part and parcel of inextricably intertwined circumstances, but that's not this case. So the brief does put out in there that the intrinsic facts the state is seeking to admit does not meet any of the criteria or exceptions, whatever you'd like to qualify it as, for those acts to be admitted. I don't know if the state is planning to respond. I did submit that several weeks.
Right, and I read it and I marked on it, and now all I need to do is find it.
Yeah,
I need somebody to keep me
and the
organized.
state hasn't responded.
Does state have a response?
We do, and
Did y'all file a response?
Nope.
No, we made an argument that essentially is the same one we're going to make today, but based on what they've put forth, we'll respond specifically to the arguments that are asserted, put forth in Ms. Abbasi's brief. I think we presented case law, and I think that the court saw that case law I won't speak for the court, but I believe the court saw and was satisfied that the case law does say the acts occurring after indictment are not precluded as evidence of the conspiracy.
Right, no, agreed, but it's two separate issues.
Yeah, I know that. I know Moonk's live. I know he's live. I just, I already started this, and I'd already told everyone that's on this live that this is what we be doing. So I'm not going to end the live to go over there. I'm sure I'll catch a live and see what's going on with him at some point this week. But I do know that he's live.
I mean, if it's going to be, they're not precluded just because they're post indictment, but if they're going to be admitted as intrinsic evidence, then they have to fall within one of the things that makes them intrinsic evidence, that it's the same series of transactions. It's necessary to complete the story, or it's in that it is.
All of them. So in as much as the arguments that are put forth in Ms. Abbasi's brief seems to focus specifically on
She's reading the brief right now.
Person state which theory they're proceeding under.
Right, yeah, you're saying it's not any of them.
Correct. I've never heard from the state which of those three.
Hey, me.
So, Your Honor, I'll just tell Ms. Abbasi in the court right now. It is intrinsic to count one. Additionally, the conspiracy that it also is a part of
this is terrible.
YSL gang itself and the conspiracy that the gang itself makes up. I think we already presented some of the facts of the case to the court regarding the in concert action by five YSL members and two others of stabbing one person in defense of Mr. Ryan. And I know that the court has already read the indictment that describes, as the state alleges, the conspiracy itself being preserving, protecting, and enhancing the reputation, power, etc. of the enterprise through acts that include assault and threats of violence, a number of actions that are intended to sort of circle the wagons around YSL members, show that they will stand up for each other and that they will commit violence on persons who they perceive as threats to members of YSL. Mr. Ryan, after he was indicted, there were several, at least one YSL member that we have listed as an overt act who makes assertions about Mr. Ryan.
Yeah, I'm so sorry.
Murder charge and subsequent, I think, conviction.
I realized we never speeded up.
And there are people who perform acts during the course of this trial. At least one person that we believe were intended to intimidate a witness who was actually on the stand at the time. There are, by way of examples or analogies of other similar acts that are committed on behalf of YSL to show their solidarity. For instance, when Mr. Garlington is jumped, other members of YSL immediately jump in. We have evidence that when Mr. Copeland is jumped, at least one person in the courtroom now jumped. Just jumped in just because when it's one of them, they are going to come to their defense. The act itself was.
Hear all of this argument, it'd be great under 404B, I'm waiting to hear which of these three categories it falls into.
Thank you.
We're talking about two different issues here. Which of the three, and then 403.
It is not 404B. It is intrinsic.
It could be both. I mean, I guess it would be intrinsic, but y'all haven't offered it as 404B, right? And you don't intend to, even if I rule against you on the intrinsic.
Baby, why Miss Abbasi stand up like that? Y'all, Miss Abbasi stood up like I stand up when I'm watching court sometimes. You just can't help it because Miss Abbasi, you're in court. She just stood up like, listen, I hear what she's saying, but can she get to the point? Like, why was she, y'all, Miss Abbasi, that was so funny. Listen.
Well, if the court ruled against this, it would be a different argument that we'd be prepared to make on a different day, because that's not something we're putting before the state.
Okay. All right.
Girl.
So the actions of Mr. Ryan and the other YSL members in concert in stabbing Mr. Bussey, when
She was.
Ms. Abbasi asserts that they're not necessary to complete the story of the crime. This is our position, is that this conspiracy didn't stop at the jailhouse doors. It's ongoing. It's necessary that the jury sees that it is ongoing to show to them the truth and the whole truth that we believe that our evidence reflects, to show them the extent to which YSL members go in order to preserve and protect not only their name, their own, but their reputation. Mr. Ryan, Mr. Blaylock, Mr. Eppinger, Mr. Myrick, and Mr. McMullen are seen in the photo that I don't know that the court needs to see it, but if it does, we can present it on Zoom camera to show the concerted action on their part in stabbing Mr. Bussey. This particular screen grab of the video, this was just all holding him down. And for the purposes of just this hearing right now, we'll just call it State's Exhibit 4C.
Y'all, it's not the stabbing that's funny. It's Miss Love. It don't have 5 arms in the air. Like, why are you, Miss Love? Y'all, she pulling out all the stops. She really did, because Miss Abbasi was eating her up. Miss Love had to say, let me just probably add some dramatics. Maybe that will help Paige. Like, come on.
65 RR for rebellious crime.
All right.
Your Honor, I guess I'm kind of more confused now. I think the state's purpose is they want to show that it's ongoing. So I don't know how they're using it to complete the story of the crime. If their version is that it's not complete and it's ongoing. I don't see how those two square. It's not an element that the jury has to find. The gang is continuing. The only thing they need to prove is that by the date of indictment, this happened. It really doesn't matter as far as what the jury needs to know for the state to meet the required elements. It doesn't matter whether the gang is continuing.
All right, but the state can prove if it chooses
They sure can.
that it's an ongoing conspiracy.
Sure, but that doesn't make it necessary to complete the crime.
Well, necessary to complete the story of the crime. And I guess the story of the crime is
Ongoing and continuous conspiracy that is YSL, its enterprise, and the members committing these particular acts and crimes for the purposes listed in the indictment under the definition of the conspiracy itself. And this act is not something that is obviously relevant to the issue of whether or not the defendants are or are not guilty of count 1 in terms of what we're alleging that they conspired to do. It certainly would be an overact under the definition of overact of count 1. So it would go to prove count 1 as to each of the defendants. It's therefore relevant, highly relevant as to that particular issue. It's presumptively, of course, the court is the gatekeeper, but
Oh my God.
because of its relevance, it's presumptively admissible. Under 403, Your Honor, there's nothing about it that is so substantially more prejudicial than probative, given its highly probative nature. Do you have a Zoom up here?
I'm sick of Key.
Considering it's
Day, wait a minute. I'm so sick of this.
all right. Ms. Abbasi, can you remind me, and I don't know which one of y'all cited Murphy. Was that you, Ms. Abbasi? The part about integral and natural part of the witness's accounts of the circumstances surrounding the offenses, which factor did that go to?
I specifically did not cite that case. I did discuss whether it would be integral and natural part of what happened. I didn't cite him.
Okay, well, maybe it was just one
I did want to touch on one thing the state said, because I think we're getting into dangerous territory.
Yeah.
The state said that this act in and of itself could constitute an overact to support the verdict. Well, now we're talking about trying to prove the charges against the defendant based on something not unique.
Well, and you know, that's an issue that I've got written down here as something that y'all owe me law on, whether an overt act not listed could be the sole basis for a conviction.
Right.
Where the law?
And I think at some point,
Still waiting on that law.
Actually, I think at some point, and I might be wrong about this, but a contrary position was presented and whatever case was cited did not support that position. And we had affirmative case law that we presented in the form of a brief to the court.
All right, will you go ahead and get that filed? Can you get it filed? When can you get it filed? By Monday? By Friday? All right, by Monday.
Your Honor, I can get to the court kind of the contrary case law. In the appellate, I know it sounds kind of, doesn't sound to swear up, but it leads to an inconsistent verdict that perhaps some of the jurors found the defendants guilty based on the acts which were in indictment, and perhaps some of them found the defendants guilty on.
I mean, it's gonna be real fun when we get to the verdict form. I think that we're gonna have to get really specific about what they're finding. And I don't think it can be that 6 found one and 3 found another and 2 found a third.
I think that this precise situation came up in Cotman, and I could be very, very wrong. I read it, I glanced over it briefly, but I think that the court found that given that the court instructed the jurors that their verdict had to be unanimous, that it did not present a reversible issue. The defense argued, or the appellants had argued, that there was no way to tell whether or not they all agreed on the same overt act. But in giving the court the brief that we intend to present, I think we can address that as well. I think that that part is easily
All right,
addressed.
so that'll be 2 different issues. Can an overt act that's not listed in the indictment be the sole basis to support the conviction? But then there's also, does the jury need to find unanimously this overt act, specific overt acts? Do they need to delineate which overt acts they are unanimously finding exist to each defendant?
Right, and I think that as it relates to our previous discussion that the court said we would address a little bit later, whether we number them or whatever, just off the top of my head, I think that them listing an act that they found unanimously had been committed as to the defendants, I think would suffice.
Okay, well, if we all agree on that, then we don't need a brief on that.
Okay, so, I'm sorry, Ms. Abbasi.
I don't know if we made it to the 403 part.
No, we hadn't. We sort of got sidetracked, but all right. So we all agree that the jury is going to need to delineate. We unanimously find this overt act exists as to each defendant, right? I mean, we're going to break each defendant's counts out separately, and
I think that.
I agree, but
well, and to make certain that we present clearly to the court, we do believe, yes, that the jurors have to make a unanimous decision as to each defendant and as to their overt acts, but as to whether the overt act it finds as to one unanimously has to deal with the others.
I know. I mean, it could be wholly entirely separate as to each defendant. It needs to be a separate determination as to each defendant.
Yeah.
But for each individual defendant, does the state agree that the jury has to unanimously find 2 overt acts, one of which needs to or happen within the statute of limitations?
We agree they have to at least find one that happen within the statute of
And
limitations.
it needs to be unanimous that, let's say they all find overt act 66, whatever that is.
I believe it's safest that they find unanimously.
Okay. All right,
And
then I don't need law on that because we'll just do that the safe way, whether it needs to happen that way or not. Okay, so back to, so I still will need by Monday whether an overt act not listed can be the sole basis for the conviction. And now we will go back to to what we were talking about, which is this
the intrinsic
allegedly intrinsic act.
So Mr. Ryan, given Mr. Blaylock is not here, but I will, since they were the 2 that were charged with the murder in one of the overt acts listed on the indictment, Your Honor, Mr. Ryan and Mr. Blaylock have entered a plea of not guilty to count one. And they are obviously charged with committing an act of violence against a person as alleged in the indictment in a manner that furthered the interests of the enterprise in the conspiracy. The three, I guess, points that Ms. Abbasi referenced in her brief were that the intrinsic or the act needed to arise out of the same transaction, a series of transactions as the charged offenses necessary to complete the story of the crime, or is inextricably intertwined with the evidence regarding the uncharged offenses. And there is an or, so it does not have to be all three. So given that the jury will hear evidence of Mr. Ryan's and Mr. Blaylock's concerted efforts as they related to Mr. Holmes, they will hear evidence of Mr. Ryan's actions after the murder of Mr. Holmes. They'll hear evidence about their connections to YSL, but the fact that you have other members of YSL acting on behalf of Mr. Ryan to support him in a violent way against another person whom they allege only messed with Mr. Ryan's commissary, stabbing him just because he messed with Mr. Ryan's commissary, show the extent to which members of YSL go to assert their dominance, even in a situation like the Rice Street jail, and to protect one another, to show that you don't mess with one of our own.
She's running out of stuff to say.
The argument obviously can be made by anyone. Yeah, this is not really what it's all about. But in terms of what the state is required to prove beyond a reasonable doubt to the jury, we alone bear that burden, given that it's evidence that there is violence committed on behalf of a member of YSL by members of YSL. We believe that it shows that the gang itself conducts itself in a particular way, and that
Okay, let's stop interrupting though. I mean, I assume she'll get to it at some point.
That the gang itself conducts itself in a particular way, and in Johnson versus State, a Supreme Court of Georgia case, whose site is 312 Georgia 481, decided September 21st, 2021, at Penn site 491. The court said that, of course, evidence is admissible as intrinsic when those three elements that we just mentioned exist. And they went on to expound and say, in applying this test, we have explained the evidence pertaining to the chain of events, explaining the context, motive, and setup of the crime is properly admitted. If it is linked in time and circumstances with the charged crime, the defendants, the YSL members, are all together. They are the ones that are included in, or that participated in the stabbing of Mr. Bussey, are all housed together at the Rice Street jail. The time frame is shortly after they're put together in that situation, all together in the Rice Street jail.
She's reading as she goes. That's the problem too. She's not prepared for this.
In this particular case, in Johnson, it has a set of circumstances that are not exactly the same as this, but we believe are analogous in many ways. In Johnson, of course, the appellant was charged with participating in criminal street gang activity, and the state's theory was that he was involved in the gambling house shootings with blood gang affiliate Porter and several unidentified assailants in another restaurant shooting. The evidence related, as the court found, to the Boulevard Place shootings added significant weight to that theory because the evidence was linked in time and circumstances with the charged crimes, and one victim was a member of a violent gang. We are not alleging that it is on all fours with our particular case, but to the extent that the Johnson court found it pertinent to say that the intrinsic act, or the act that the state alleged was intrinsic, added significant weight to the state's theory for these reasons. We believe that that is analogous to our case as well, with 5 people, 7 total, acting in the same, overacting with an extreme amount of violence on behalf of one person whose connection we believe with the 5 YSL members is just they are all YSL members and they are acting protectively towards him. We have, we believe that incident adds significant weight to our theory of the willingness of YSL members
I'm gonna pause
to participate.
This is someone asked me, this is day 127. I do have to stop it. Y'all know I'm going live on TikTok. I would love for you guys to come over and join. It's not going to be YSL related. This is one of my great friends. My daughter calls her a hippie. The other day we were on live and the live kind of took a turn and we talked about a lot of stuff which normally happens. Normally happens on these lives. They go everywhere. And what I felt from that particular live is that it would be helpful to have a therapist come on. Hold on, y'all. My alarm going off. I saw that it would be helpful for my community, especially to just hear from a therapist. We had a couple of questions in there and I can't answer them. I'm not a therapist. So I text her while I was on the live. I'm like, hey, would you come on my live and just kind of talk about therapy, talk about people going through their healing journey? Yeah, I pray I don't get on here and cry because, yes, I know Melanie needs therapy and I talk about it all the time, but I have not gone to grief therapy since my mom passed and I know I need to go. But so listen, excuse me if I get emotional on there, but I would love for you guys to come on. She's really great. She's in Georgia. So she's in Georgia. So if you're in Georgia, she may be a great person, but if anything, just come get some information, guys. And just see. So I'm about to get off here and start the TikTok live so that I can let people know what's going on because I know she's going to be in the comments. And I already know somebody's going to come on this live like Mel, Tounk live. Mel, you see what happened to Tounk today? I know that's going to happen, but we're going to press on, guys. So thank y'all for streaming with me today. We've been on live 3 hours today. Some of y'all been on here the whole 3 hours with me, and I appreciate y'all so much. But I'll catch y'all later. Y'all enjoy the rest of your night. See y'all later. Bye.